mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running the theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one." Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess what's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one."
Hey everybody, welcome back to the channel. Happy Thursday or whatever the hell day it is. Oh, it's been a day. However, I did finish editing my other video. It will be dropping at like 4 o'clock, 5 o'clock tonight. And today we have Utah versus Tyler Robinson hearing. This one, I've been so busy today, I didn't even bother to try to write or think or come up with some sort of intro because there is nothing funny about this case. There is nothing creative. There is nothing sarcastic. There is nothing petty. This is just a really sad motherfucking situation that we just have to learn to manage. This hearing is about a couple of motions that were filed by the defense wanting to seal records or wanting to seal hearings and keep media out. We'll see what all they have to say. We will go into the files sometime. Hopefully, if this is not too long, we will go into some of them today. I do have them, courtesy of Andrea Burkhart Law's Substack. She has provided them ever so graciously to people via her Substack. She might have it behind a paywall. I support her Substack because she's awesome like that. If you don't subscribe to her, go subscribe to her. She's freaking amazing. However, there has been a lot of controversy with this case up until yesterday with Erica Kirk going on Fox News and talking to Harris Faulkner about everything going on, and basically calling out Candace Owens. I am not here to call anybody out. I am on the side of facts, and you can tell who in this country has absolutely no freaking idea how the court system works, just solely based on the fact that you've heard people say, well, we want all this information, or this is not happening fast enough, or this isn't. Welcome to the fucking court system in 2025. Excuse my language. This is not how anything works. And at the end of the day, this is the state case. Charlie Kirk was a high-profile person, but at the end of the day, he was just a civilian. He wasn't a government personnel. This is not a federal case. The FBI is assisting, not the main characters in this investigation. There's been so many rumors out there that are like, y'all, Y'all. But how is everybody doing today? This hearing should start at 2 o'clock. I have it up. We are going to just sit and listen. Oh, we'll see how it goes. And if my blood pressure starts to rise. But I like operating in facts on this channel. Y'all know that. We don't do conjecture unless it's educated conjecture and backed up by facts, or it's us just brainstorming what we think might be going on. But I never present and never will present anything of my opinions as fact, because that's just not how we roll around here. Jeffrey, good. I'm glad you got the 30-minute warning. Thank God YouTube is starting to actually, since I started that second channel, people are actually getting notifications for this one. I don't know what is up with that, but I'm not complaining. Gail, yes, hit that thumbs up on your way in. Please do. Please share. We are trying to make it to 5,000 subscribers. What if I'll ever get there? I don't know. We're at like 42, 30 something. But I did recover all the subscribers that I lost in the last month and a half. So we're back to baseline. Andrea, how are you? Storm Killer. Ammo's girl here lurking. You lurk away. You got here just in time. Yeah, I started this stream early because courts are notorious for, well, either being on time or sometimes early or sometimes late. You never quite know what you're going to get with a hearing. So I always start, the hearing's supposed to start at 2 o'clock. I always start early just to make sure that I said hi to everybody. We got our intros and all the obligatory stuff out of the way, and that we don't feel rushed, because I already feel rushed enough. However, I did get 30 minutes in the sauna blanket today. So amazing. Did not get a workout in, but I got 30 minutes in the sauna blanket, so I'm feeling like I did something for myself. Tree God, thank you for the $2 super chat. Good afternoon, Miss Squid. Merry Christmas season. Merry Christmas. Happy holidays. Happy Hanukkah, Kwanzaa, whatever you whatever you feel the need to celebrate, or I don't, it is what it is. I'm all over the place today and my phone is blowing up. Ground. There we go. And Stanley, hello from Levy County. How is our little Florida? I want to say a hole in the wall, but y'all just want to be left alone. I'm convinced y'all are just a small town people who just want to be left the hell alone, and you're infamous for all the wrong reasons. Hey Jeff, how are you? Oh, Jeff, so I couldn't do your story justice today, or justice, the story you sent me. So I forwarded it to Mo. It was story number 1 on her her morning news this morning. So go check it out. And Jen, and I hope I shared audio. So courtroom audio is notoriously shitty. So I'm sorry in advance. Oh. An error occurred on their side, not our side. Hey, Joe. Maybe people do not deserve as much as information as they think they do. Yeah, that's the thing. People think they're entitled to everything, and they're just not. But I was talking earlier, and when I covered this when it first happened, was all these people and their conspiracy theories. That is just more for the defense to use, is why this person may not be the person. And I have thoughts. As far as people saying the weapon used, there was no way that could have been the weapon because, that's too big of a caliber, whatever. I refer you to Martin Luther King was literally shot with the same caliber, and there was no exit wound. I'm not saying that, I'm just giving people plausible I'm just giving people plausible explanations for things that could happen. I'm not saying that's what happened, but that seed of doubt of there's no exit wound. Okay, you act like that's not happened before with a 30-06. Martin Luther King, Exhibit A, shot with a 30-06. No exit wound. Can't tell me that hasn't happened before. The episode of Squid Pro Quo is brought to you by Levy County Sheriff's Crime Stoppers. You report them, we ignore them.
You'll remember one day.
All right, I'm going to shut my door here because the little is watching TV really loud, and I want to make sure that all the audio, there's no audio from me.
For sure. Start talking about this.
There we go.
We will address that.
And one of his lawyers was one of the lawyers for the Menendez brothers. So if you know that case.
40 times.
Hey, Malin. Happy early birthday. He got his wish to be in real clothes. I bought the sauna blanket as a Christmas present to myself. I've used it like 4 times, and I love it. Hey, John, how are you? It's so good to see you. This sauna does have a manufacturer's name. I love the thought process there, but I'm just going to keep it to myself for now. Hey, King Paco. Hope you guys are having a wonderful day. Are you still addicted to your Nintendo? Good. There's been a lot of stuff that I haven't been able to cover, but I've been kind of keeping my eye on. So it wasn't me, Jeffrey. It was them. It was their feed that needed a refresh, not me. The one thing that I've noticed with this is he's never come out, none of his family has ever come out and said he's innocent. If there's a whole bunch of people that said that he's a fall guy, they would have said he's a fall guy. There's multiple sources involved in this. He's a fall guy. He didn't do it. No official person from his defense team or anybody has ever said anything. All these conspiracy theories are people just... And if you want, I can go through his lead security guy sat down with, oh my God, I can't remember the name of the podcast. I watch it all the time and I can't remember. That person, if he ever watches, is going to be like this quick. Sean Ryan. He sat down with the Sean Ryan show and kind of discussed it. And that would be an interesting interview to go through if you guys are interested in that. Gail, I am so sorry.
It's kind of weird. Like it.
Weird.
Yeah.
And hi, Thursday Angel. The thing about them wanting to keep the media out of this and keep things behind closed doors is whether Tyler Robinson did it, he's being framed, or he's completely innocent and had nothing to do with this, and whatever. Charlie was shot on live TV, basically, in front of thousands of people, in front of the world.
All rise.
And why should court hearings and trials and evidence be kept secret
Please be seated.
when Charlie wasn't afforded that privacy? People want to know where his damn grave is. Who the hell
Court
cares?
is now in
It's none of our
session.
business. I need a gavel. That's what I need.
Counsel, if you could enter your appearances, please.
Your Honor, Christopher Ballard, Ryan McBride, Chad Grunander, and Lauren Hunt on behalf of the state.
Good afternoon.
Good afternoon, Your Honor. Kathy Nestor, excuse me, Richard Novak, Stacy Visser on behalf of Mr. Robinson.
Good afternoon.
Good afternoon, Your Honor. Jeff Hunt and David Ryman appearing on behalf of the media interveners that are identified in our motion papers.
Good afternoon.
Michael Judd, Your Honor, Parsons, Bailey, and Latimer, on behalf of another set of media interveners also identified in the briefs.
Good afternoon. And I recognize Mr. Robinson in the courtroom as well. Good afternoon. And for the benefit of the record, calling case 251-403-576, State of Utah versus Tyler James Robinson. Counsel, as we're moving forward today, I want to give an overview of what we anticipate doing. And it comes down, we're addressing three issues. The first is the October 14th, 2025 audio recording of the closed hearing and the October 24th, 2025 transcript of that hearing. The second is the state's motion to amend or clarify the publicity order, commonly known or referred to as the gag order. And finally, the motion for limited intervention and request for notice of motions to close, seal, or reclassify, and which has been filed by the media organizations and by counsel who are present today. So as we begin, the first part is we'll begin by addressing the October 14th audio recording and the October 24th transcript. This portion of the hearing will be closed so that I may hear from the parties regarding which portions of the recording the record should remain sealed. All members of the public and the press will be excused, and the hearing will not be broadcast. This is because I need to hear what should or should not be sealed or protected, and it would not benefit to have everyone listen to what should be sealed. And so after I've heard argument, we will invite all parties or the public and the media
I will be
to
right
come
back.
back
The
in,
little has
and the hearing will resume transmission.
want something.
We will then take up the motion for limited intervention, followed by the state's motion to amend or clarify the publicity order. These portions, the last two portions, will be open to the public and to the press. After hearing argument on all three matters, I will take a brief recess and then return to issue my ruling today. We will then stand in recess. So at this point, we'll go ahead and excuse the public and the media, and it is the court's order that transmission be terminated temporarily.
Your Honor, we have one request with respect to the closed hearing. May I be heard on that?
Yes, counsel.
Thank you. Richard Novak for Mr. Robinson. Mr. Robinson has some immediate family members who are present, his father, his mother, and his brother. And we would ask the court to permit them to remain in the courtroom during the closed portion of the hearing.
To the state.
My only concern with that, Your Honor, is that we're going to be talking about court security measures. And I don't know that we'll have to go into a lot of detail about that, but I do have concerns about those issues being discussed in public.
All right. Mr. Novak, do you have authority that supports allowing them to remain in a closed hearing?
No, I think it's subject to the court's discretion to decide who is and is not an appropriate member of the public. I think they have a unique relationship with Mr. Robinson, and they would certainly abide by any orders the court makes concerning disclosure of what is discussed in closed session. But obviously, it's up to the court.
Thank you, Mr. Novak. I'm going to rule that they will be excluded as well. It is just given the nature and the sensitivity of it. I believe it is appropriate to treat all parties in the public equally, though I do recognize their relationship with Mr. Robinson. Thank you for your request. All right, we will go into the closed session. Thank you.
Well, he speaks super, super slow, but I really like this judge. Like, I really like this judge. He's very by the book, you know? He keeps shit on schedule, but he did say at the beginning of this that he was going to try to be as transparent as possible. With that being said, I'm interested to see what the arguments are going to be here. While we are doing that, I am going to open a couple of the documents that they are arguing about. So I will keep an eye on it here. But we the way she has this organized, it's the newest at the bottom. So this is a reply to a motion. Come on. There we go. Seeing a good judge is a change for us. I know. Well, Judge Arthur in Mississippi was is a good judge too, but you know, yeah, well, considering his family are allegedly the ones who turned him in, it's an interesting conundrum that and here's the thing. I know their parents. I know it's a it's a hard thing. I can't imagine what the parents are going through seeing surveillance footage and recognizing your child. I can't imagine what they're going through. So in one point it is their son. It's a situation I don't have words for. But we are going to go over here. We got all these scenes set up. I'm getting better at it, but unfortunately, our good old StreamYard is not the kind of person that will let me.
Today on Court V.
Yep. So, in my opinion, this hearing is happening because the state is too lazy to redact security stuff. I'm not sure. It's and I think so. I have not actually seen any of the Discord stuff. I heard rumors about the Discord stuff. This is my problem right here. Right here. Thank you, Hey Joe. People that supported Charlie Kirk are not out to kill him. There's certain issues that I'm seeing from people, and it's like, do you realize that's not how that shit works, right? It's so hard to put into words how I feel about that, but it is just one of those weird situations of like, everybody wants mob justice. And we all want instant gratification. We all want to know what's happening right then and there. Some people are all about who can get the story out first, as you've seen with the mainstream media. Half the time their facts aren't right, but they want to be first. They want to be sensationalized. They want to get those clicks. This is not something that you can sensationalize, because at the end of the day, you have to remember that somebody died. And a person that a lot of people really looked up to as how to be a better person, how to be a better person, died live on TV or with lots of cameras. I don't think it was being streamed. However, there was cameras and it was posted immediately, and I've seen it, and it's not pretty. It's just, yeah, they're not like the killers, the media, and the TDS folks are so stupid. I wouldn't say some of them are stupid. It's just some people, when they're presented with facts, want to believe what their emotions are telling them and not what their facts are. It's just it's a hard thing to you want answers, and as a society, because he was a public figure, we want answers. However, we all have to understand that we are not going to get answers. But the psychology of the brain, if you do not give answers to something and there are unanswered questions, the brain will form. The brain doesn't like to not know things. The brain needs a story. So sometimes when things happen, the brain fills in information. It's why sometimes when you remember stuff and you don't remember stuff accurately, it's because one, the brain can only pay attention to one thing at a time. And secondly, when there's a lack of information there, your brain will actually fill in information to make things make sense. And the problem is with a lot of court cases and with a lot of life in general, things happen that just don't make any sense. And this is where I would say I'm not a conspiracy theorist. I'm a realist. It just so happens that the conspiracy theorists are up like 20-0 since, around 2020. With that being said, when we aren't given information, the brain will form a story, and I believe that in history is where a lot of conspiracy theories come into play. I bet there are no protests outside the courthouse either. Probably not. Just finished the 11. Oh, no. Yeah. I need to move south. Yeah, my dad is like, I need to move south soon. I don't think there should be a media camera. Stick to the courthouse technology. I am all about a pool feed, a camera, just like there was for Laura Owens, just like there was for Sarah Boone. One camera. You're not going back and forth. You're not showing witnesses. Like, you don't need to zoom and pan and make it a production. You just need a pool feed that is better than the courtroom cameras, because the courtroom cameras and the courtroom audio really suck. As we've seen. We probably won't get a ruling today. He'll probably just hear all of this stuff. But you never know. You never know, because he's had the motions for a while. My issue is that this man's senseless death somehow garners more attention than the dead on air at the LDS Church massacre of attendees, including children. Yeah. The problem, and I see your point, I don't disagree with you. It's just one of those things of, this person meant a lot to, he was a public figure, and public figures are always going to get more media time. It is what it is. Yeah. TPUSA wants to change and debate and try to change minds. They don't want trust me, if the right was the most violent people, like between here right at my desk, like if the right was violent people, we'd know it. With as many people as with as many people that have pews in this country, if the right was as violent as the left makes them out to be, you would know it. And I don't want to make everything like left versus right, but like sometimes you just hear shit and you're like, you call people Yahtzees and all of this and evil and that, and then you wonder why people go and unalive other people. It's because you've devalued human life by senselessly name calling someone because they voted different than you. When you call people every name in the book, you make it that their life isn't worth anything. So when someone goes, "Oh, I don't like them," I can unalive them because their life isn't worth anything. This is the huge problem. Yes, and we have a mental health problem in this country, just in general. Untreated mental health. We went from having it stigmatized as having a mental health condition and being stigmatized because of that to celebrating it. There's a happy medium somewhere, right in the middle, where it's like, we're not going to stigmatize someone for having a mental health issue, but we're also not going to put them on a pedestal and celebrate them. We are just going to get them the help they need. Yes, Kirk had a profound effect on people, especially young men. I saw my son cry for the first time in years when he passed. It's and he wanted to talk with people he didn't agree with. But I don't, this is not something I joke about. So saying I joke about this is the right word, but like a sarcastic quip back. When people say the right are violent, well, you just unalived the middle. Charlie Kirk was literally the middle. Yes, a Christian conservative man, but wanted to talk to other people and figure out why they thought the way they thought and present them with facts, not call them names, not belittle them, just present them with an alternate set of facts, also known as the reality of life in most cases, and give them more information and let them see if that changes their mind. He didn't name call, he didn't belittle. And when you belittle someone and you name call, it's like, what's the point? You just drop down to their level. It's, yeah, they wanted to silence him and they literally turned him into a martyr. If you're happy and you know it, no. It's if you're happy and you know it, shake your meds. Yes. Yeah, Kirk was on a screamer. He asked questions. And even when people did scream in his face, he was like, he'd put down the mic and he'd be like when South Park did their parody of him, they had what Cartman set down the mic every time because that's what he did. So it's putting a bug in their ear and calling into question their fundamental assumptions of reality. Yeah. And and it's like, you can also tell when people talk whether they've actually been through the shit or whether they're just all talk. Yeah, it's just it all adds up. You can't do the type of stuff. I remember when folks were sending Obama emails and I blocked them or told them to knock it off. That's our president. It's wrong. Yeah, it's wrong from both sides. And it does happen on both sides. I'm not denying that. But there is people who unsubscribed to me and hate watch because when I first started talking about this, I was like, Tyler Robinson is not a right-wing extremist. Not in the least bit. And also, just because you have conservative parents does not make you a conservative person. I'm just saying. My mom, growing up, my mom was a liberal. I'm not. I mean, I'm more like a libertarian, and the older I get, I'm becoming more of an anarchist, but hey, there's that. Never in a million. Yeah, I never really want to make this a political topic, but this is unfortunately a political topic. It's one of those things of I've said it before, and this is kind of my opinion that I'm sticking with in general. Obviously, this is not everybody. I am not painting everybody with a broad brush, but the right thinks the left used to. I can't say this anymore because I'm pulling farther and farther away from this. This the right thought the left was good people with bad ideas. The left thought the right were just bad people, which, as we've talked about, putting certain people in, sending people to Lord Chippy, as Mo calls it, and other such things. Even we jokingly have put down the value of human life. Like, I was updating, I go through ChatGPT, and I have ChatGPT just run searches on key names every day. It saves me the 20 minutes to 30 minutes of going through and Googling every name and case that I'm covering. So it does it does a search for me. And I was looking at all the cases that it was searching for me today, and it said no news on Christopher Schultz. And I said, you can take Christopher Schultz out of the names of cases that I'm covering because he self-deleted. And it was like, ChatGPT wrote back, if you or your audience need like support on, a difficult topic to talk about, blah, blah, blah. And I was like, I don't care. The guy pled guilty to leaving his 2-year-old daughter in a car and letting her basically roast from the inside out. I could care less about what happens to him. And then I thought about that, and I was like, wow, that makes me no better than somebody else in the devaluing human life. So it's this very like weird conundrum that we find ourselves in. It's, I used to be very liberal and now I'm more conservative, but my daughters are diehard liberals. I shouldn't say diehard, but they're liberals. So I would say that I would probably be described as a classical liberal. I'm more like a libertarian. I just want the government to stay out of my life. Like, let me raise my kid. Let me teach her. Let me be in charge of teaching her about the birds and the bees. I don't need the school to do that. You just teach her, health, body parts, hormones, stuff like that, like health class, physiology. But I'm more like I like my 2A, but I also don't think certain things should be illegal in like the, um, Mary Jane kind of situations. But that used to be a liberal. I think you marry who you marry. I don't care as long as it doesn't affect me or it's not out for kids to see. Like, you do what you want behind closed doors. I really don't give two flying fucks because it's none of my business. I don't think it's the government's business either. Um, it's like same-sex marriage. I don't necessarily think that it's not that I think that the government shouldn't allow same-sex marriage. I don't think the government should be involved in marriage at all. That's not the government's place. That's between people. That's between citizens. I don't think the government should be involved in my private life, whether it's between a man and a man, a man and a woman, a man and a tree. I don't care. It's none of our business. However, as long as it stays behind closed doors, because I don't like to see any of that stuff ever. Like, I don't like to see people make out. I don't like, it's just not my thing. So it's just one of those situations where it's like the government is overstepping. Just leave the kids alone. Leave the kids alone, keep it off of social media. Like, I don't need to see your no. I don't need to see certain things that I've seen, especially recently. I got an email. It freaked me out. But I have to go real quick. I'm going to put this court TV stream back up, and then if I'm back, I have to go change a diaper, by the way. If it doesn't by the time I'm back, I have not. This is a different ring. This is like this is just a cheap ring. Takes the place. But I am going to bring the other stream back on the topic. And if it's not back by the time that I get back, I'll go into that document. All right. Yep, as good as thanks, Gail, for keeping everybody updated. I'm tempted to go over to Danny's stream since she's a lawyer in Utah. Yeah. See ya. You got to do what you got to do. So we are going back to that document. All right, this is the defendant Tyler James reply to media's memorandum opposing stipulated motion to classify as private the transcript and audio of October 24th. Y'all need to get off my lung. Yeah, not surprised. I don't know. All right, defendant Tyler James Robinson, by and through undersigned counsel, hereby files this reply to the media's memorandum opposing stipulated motion to classify as private the transcript and audio of October 24th hearing, filed December 8th. This brief reply is intended to clarify the procedural history of the matter at issue and Mr. Robinson's current position regarding the transcript and audio from the hearing. Hey, Gail, it's a free country. While Mr. Robinson did not request that the October 24th hearing be closed, the court's decision to do so was well within its discretion. Mr. Robinson did not request that the hearing on October 24th be conducted in a closed setting. October 9th, Mr. Robinson filed defendant's motion to appear at all in-person proceedings in civilian clothing. Oh, I hate that. Not even Sarah Boone was given that. Like, come on. And without restraints, in memorandum in support, docket number 83. In that publicly available filing, Mr. Robinson requested temporary relief from the court as follows. An order compelling the Utah County Sheriff Department to disclose any and all files, records, correspondence, and reports created by or in the possession of the department relating to the motion. A temporary order allowing Mr. Robinson to appear in civilian clothing and without visible restraints at any in-person public hearing held prior to the determination of this motion. Good work. A closed hearing for the court to receive evidence regarding the need for physical restraints in this particular case and the opportunity to further brief this issue. Y'all be nice. Be nice. At the time the motion was filed, Mr. Robinson was due to next appear in person on October 30th. In brief, Robinson requested the court allow him to appear in civilian clothing and without shackles at all public hearings prior to the hearing on the motion, including October 30th. Anticipating the possibility of a need for a closed setting for evidence on court security measures, Mr. Robinson also made a request to schedule that hearing to take evidence in the future. This never occurred. Rather than in an effort to expedite the determination of Mr. Robinson's motion before the October 30th, 2025 hearing, the court ordered a truncated briefing schedule. The state filed a response to the motion and requested that its response be classified as private. See, that's weird. Just so weird. The court granted this motion, and the state's response continues to be classified as private. On October 23rd, Mr. Robinson publicly filed a reply in support of his motion. The parties were notified by, and then the footnote, Mr. Robinson does not offer comment or argument regarding the other issues raised in the lengthy brief filed by the media concerning the nature of electronic media coverage, as it is not an issue for the hearing on December 11th. Oh, yeah, 21 inches would bury us in Georgia too. We'd be out for a while. We'd be buried. All right. The parties were notified by the court on October 21st that the matter was to heard on October 24th. On October 23rd, the court notified the parties that the hearing would be closed and sealed. This seems like just a whole bunch of shit about nothing. Like, I'm sorry. Like, maybe it's just me, and I know that there's procedural issues and stuff here, but like, this just seems like there's like hundreds of there's just hundreds of pages of documents like for nothing. It just seems like a big ass waste of time. And this is one of the things that I'm critical of the court system for, is that we waste court resources and time on this shit. Like, sorry for my, and this is why I'm not a lawyer, and this is why I can say shit that a lawyer wouldn't say or couldn't say, because I don't have to maintain the integrity or the decorum of a lawyer. Whereas certain people who are lawyers, good for them. I'm not. No. Like, I worked in medicine. You know, it's the same but different. On October 23rd, the court notified the parties that the hearing would be closed. Notably, the motion, reply, response hearing were held prior to any media entity requests for notice of motions to classify or close. See docket notes, or docket numbers 150 and 164. Having not requested notice, the media were not entitled to notice or the opportunity to be heard under Utah Rule of Judicial Administration 4-202 regarding the October 24th hearing. It's just, Andy, thanks for the $2 super chat. I'm just here for the footnotes. Yeah, the footnotes, I always pay attention to the footnotes, because I've even heard lawyers say, notably one in particular that says, I don't read the footnotes. The most interesting information, and sometimes the snarkiest information, is in the footnotes. So the footnotes are always worth reading, especially if you're a petty princess like me. Yeah, chat like the playground, respect all. Yeah. Or if you don't respect all, just keep your mouth shut. Although the algorithm likes the number of chats to increase, I, however, am one of those people of, if you can't say anything nice, if it ain't your house, keep your damn mouth shut. Just my personal opinion. Just a shot in the dark. Yes, we can disagree without being disagreeable. Courts argue about this shit all the time. Like, Sarah Boone filed freaking 30 motions, and I use her as a case study because she's literally the first case that I covered on my channel where I had access to every single document, because Orange County, Florida is just like that. However, so I use that as a case study because I saw every hearing in that case. I saw every document in that case. From the beginning to the end, and most of it was covered on my channel. With that being said, there were certain things that were filed in that case that didn't need to be filed. I understand procedures, but there has to be a better way to do it without wasting court resources. It just seems like it takes away, it's a diversion. And I understand there are procedures that have to be met, but it just seems like there should be a more streamlined way to get shit like this accomplished than 4 different motions and a hearing that wastes everybody's fucking time arguing about whether some shit should be sealed. It's just, This court's decision to hold a closed hearing on October 24th is in order to safeguard court security information and ensure Mr. Robinson's constitutional rights in connection with appearing with shackles prior to the ultimate determination on the motion. Was well within the court's discretion whether or not it was, and it was not, at the request of Mr. Robinson. Yeah, algorithm likes the banter, by the way. I'm just not a fan of the bullshit sometimes. Like, yeah. I have to, I have to return a message real quick. And I know you're lurking, the person who just messaged me. So, yeah. Lurk on that. Hey, Snipe Hunter, thanks for becoming a new YouTube member. Oh, someone just texted me and said I walked into your house and helped myself to the fridge. What you gonna do? 45 ACP. Do you know anything about Apple computers? Yeah, I've had Apple everything since I was 2. My first computer was an Apple IIc in 1988. So yeah, Apple. I have an Apple now. Why? What's up? You'd think they'd come up with rules regarding what should and should not be sealed and free the judge from making those determinations, except rare, odd circumstances unique to a case. And I understand in a way why things are the way they are, in a way. With as many counties and states we have, is just every county has different things than every state, and then federal, and you have circuit courts, district courts. It's so crazy that there's just so many judges and so many different things that I'm surprised it hasn't. It's just the way our country works that it's not feasible. But I feel like there should be a way without stepping on toes. So, you have a comment about something I said earlier? And you're trying to get your first one, and I don't want to make a big mistake. King Paco, this would be the man to talk to about Apple computers. Because, yeah. In the 60s and 70s, both Republicans and Democrats had the same educational background. So when we disagreed on policy, we could actually articulate our thoughts and talk about it. Yeah, articulating thoughts. That's a really hard thing. And talking about things without getting angry is the problem. All right. Footnote 2, Mr. Robinson is cognizant of the fact that the media were not present at the hearing and are, at present, unable to review the records from the hearing and thus were likely unaware of this fact. You know, Mr. Robinson's motion to classify was intended to expedite obtaining the transcript and unseal it so that the parties could review it in order to determine if an interlocutory appeal should be sought. Okay, that we're gonna have to break. I saw your part too. I'm just moving on because I have to get through this. We're only on page 3. The media fundamentally misunderstands the classification process and Mr. Robinson's motion to classify. This likewise requires clarification. As explained in his motion to clarify, the October 24th hearing was closed and sealed. As a result, the records from that hearing, including the audio, were presumptively sealed. Shocker. We didn't have any bananas, and I'm from Wisconsin. I'll never be out of cheese. love this chat. What kind of apple is it? Is it an apple, a pineapple? Jesus. Y'all crack me up. And not that I agree with this motion, plain devil's advocate, but the media fundamentally misunderstands the classification process. The media fundamentally misunderstands a lot of shit about the court system, and therefore they fundamentally cause the general public to misunderstand shit about the system. Wait, what? Have you given me any orders on what to do on the internet lately? Dude thinks you and good. Oh. Who? I don't have time to. The only person who I'm giving orders around here is my daughter. And that's fucking hard enough. Like, I'm going to give a grown ass man. Wow. Girl, you're going to break that. You're going to break it. You broke it? Yeah, you did break it, didn't you? Hold on. We have to go into, come here. Bring it here. Mama has to go into, handyman mode. You sat on it and broke it, didn't you? No. Don't you wave your finger at me. Yeah, it goes on there, but I don't know how. Oh, there we go. Oh. Girl, let go. Let go. Let go. I have to play dolly stroller handyman real quick. Here you go. Don't sit on it. You're too big for it. It's for your baby dolls, not for you. You have your own. Yeah, Daniel's a good computer guy too. But my dad knows Apple. Just saying. From an Apple perspective, it's Squab Mom. It's for your baby dolls. She tried to sit on it and she broke it. All right. This classification prevented the parties from even ordering a transcript for their own litigation purposes. That's interesting. The Utah Rules of Judicial Administration 4-202.03. No one may access a sealed court record except as authorized or by order of the court. A judge may review a sealed court record when the circumstances warrant. So, okay, if I'm understanding this correctly, layman's terms, it was classified so neither party could even order a transcript for litigation purposes. So they had to request a unsealment, basically. They had to write a motion to unseal the documents so that they could get it for their own purposes to litigate the case that they're working on, not so that the media could see it. It's interesting. What broke? Her baby doll stroller. It didn't break. It came off of the seat came off of the little metal pieces that it's supposed to stay on. Oh, shoot. All right. The court reporter required an order from the court in order to prepare the transcript and in order for the parties to review the transcript without violating the rules of judicial administration. The classification of the record needed to be lowered from sealed to private. The state stipulated Mr. Robinson's request, recognizing the difficulty in potentially seeking appellate relief without having a transcript from the hearing at issue. It's a good point. In time, you'll be talking about what Little Squid did as a kid when she's all grown up. Oh my God, please don't rush it. Like, I can't believe she's already 3. Like, Squid is now a licensed doll stroller repair person. Yep. Oh boy. And that's also a really good point. The state stipulated to Mr. Robinson's request, recognizing the difficulty in potentially seeking an appellate relief without having a transcript. The appellate court would be like, well, what are we arguing here? You didn't give me any information, because you can't provide them with the transcript because you don't have the transcript because it's sealed. I think that's different in Florida, where when the word sealed in Florida means that you changed it. That's you. That's not a baby. That's you. It's she changed. She has my iPad, and she changed the background on my iPad to her. You did it. Oh, do you want it unlocked?
Yeah.
Okay. Here. Nope. Hold on 1 second. Gotta mute. Already likes the look of herself. Yeah, she also needed me to unlock it. So, she likes drawing using my Apple Pencil. And it's like, oh, you can draw on my iPad where you're not going to make a mess and I'm not going to have to paint the walls. With this motion, as normal procedure, Mr. Robinson submitted a proposed order. Had the court sign the classification order as filed by Mr. Robinson, this would have been entirely proper. Under Utah Rule of Judicial Administration 4-202, anticipates that the reclassification occurs temporarily, instructing that upon filing a motion to classify as private, protected, sealed, safeguarded, the court must deny access to the record until the court enters an order. Signing an order temporarily while awaiting a hearing is exactly what courts are required to do in these circumstances. Nonetheless, the court properly issued its own order requiring heightened protections above that which the private designation generally provides. Likely due to the sealed nature of the hearing, see docket 172, see Utah Rules of Judicial Administration 4-202, identifying who may access a private court record. And this is different than Florida. And this is the difference between states, and why just because you are a lawyer in one state does not mean you can go and practice and be good at practice in another state, because states have different rules. Every state is like its own little country. They are seeking, I think they are seeking the death penalty on this. So, yep, I can't help you, baby. You gotta learn on your own. So up and over. There. Up and over. You gotta hit them both at the same time. You're welcome. She's using manners now. We say please and thank you. Or please. In its opposition, the media also requests the opportunity to review the transcript in its entirety prior to the court hearing argument on this issue. On this rule, 4-202.04 is clear. The court clerk must deny access until a closure determination is made. Although it may be frustrating for the media to have addressed the factual matters partially unavailable to them, the media's request violates the rule upon which it relies. Holy crap. With these procedural clarifications that Mr. Robinson sought to broaden access to the transcript and audio, Mr. Robinson turned to the media request to classify the hearing transcript and audio as public. Mr. Robinson does not object to the classification as a redacted transcript as public. If we have a redacted transcript, that would be awesome. Well, they already said that they were probably going to be seeking the death penalty from the very start of this case. On December 4th, Mr. Robinson filed a joint status report of the parties concerning the redaction of portions of the transcript of the October 24th hearing. In this, Mr. Robinson and the state agreed that with the exception of those portions of the transcript as to which one of the other parties proposed redaction, the balance of the transcript may be classified as public. Both media entities, Desert News et al. And the Salt Lake Tribune, were served through counsel by email with a copy of this joint filing on December 4th. The media acknowledges this in their filing. Footnote 3, Mr. Robinson's position is the same regarding the audio of the hearing to the extent it is possible to redact the recording of the hearing to remove the content the parties seek to redact from the written transcript. Mr. Robinson does not object to the release of the resultant audio. Yummy. I'll see you later, Spawn. Outside of potential discussion regarding each party's requested redactions, the media and the parties are in agreement. It is anticipated in the court's order that the discussion of the redactions will occur at the closure hearing. The court will hold a closure hearing in this case. The closure hearing will remain open to the extent possible, but the court will consider closing portions of the hearing to allow for the discussion of secure information by the parties. Representative of the media will be allowed to participate in closed portions of the hearing, but they are ordered not to disclose any part of the closed hearing to their clients or any other person or entity. Interesting to see if that will be leaked. Because, not a lot of people in this world, especially lawyers, can keep their freaking mouths shut. Yeah, that's why they're fighting like this. They're basically trying to fight to keep their client alive. Like, is the goal. Mr. Robinson's only goal is to avoid media circus, which deprives him of his right to a fair trial. As the above should demonstrate, Mr. Robinson has not sought to exclude the media from these proceedings. Mr. Robinson's constant refrain in responding to the plenary of media filings that this court must make appropriate findings and orders that protect his constitutional right to a fair trial in the midst of what could quickly become, or perhaps already has become, a media circus. I mean, when you're accused of unaliving a public figure, it's going to be a media circus. When it's think Kyle Rittenhouse. If Kyle Rittenhouse wouldn't have been in the middle of a riot, and anybody who wants to come in my comment section and say that wasn't a riot, I lived in Wisconsin at the time. It was a fucking riot. You can't. It's a public and a hot topic and a very well-known event. When I moved to Georgia and they asked me where I was from, I would say like a half an hour away from where Kyle Rittenhouse was from, and everybody instantly knew where I was from. That being said, it's one of those situations where you're accused of unaliving a public figure, and it's going to be a media circus, because if it's already a issue that is in the media, and Charlie Kirk was in the media a lot because of what he did, it's just what it is. And there are ways to get a fair trial, because it obviously happened for a lot of people. It happens all the time. Bring back the old chain gang, give him 20 years of hard labor. I was at the gym the other day and we had to run. But basically my 800 meters of a run, or 800 meters of a run is running to the police station and back. Well, as I was running past the police station, there was somebody washing all the cop cars, and I looked, and it was a county inmate. It's like, part of you being here is you're going to be filling potholes. You are going to be washing our vehicles. Like, welcome to jail. I wonder if Charlie's family supports the death penalty for this guy. I don't know. They have been quiet. I don't know. I wouldn't doubt it, but they're also very Christian people, so they're better Christians than I am. I always say it's not my job to forgive, it's Jesus's. So you know. Such orders should include establishing clear parameters on the media's role and concrete procedure for the media to seek relief permissible under Utah Rule of Judicial Administration 4-202.04. Further, Mr. Robinson asked the court to provide deadlines for media objections to motions to classify or close in order to avoid last-minute filings, as was done here. Mr. Robinson served Desert News and the Salt Lake Tribune with the motion to reclassify on November 13th. Motion deadlines are governed by Utah Rule of Civil Procedure 7, requiring opposing memorandum to be filed within 14 days. Accounting for the Thanksgiving holiday, the media's opposition should have been filed November 28th. Instead, without communicating with counsel for the parties regarding the need for additional time, the media has filed its briefing 10 days late and only 3 days before the hearing. As this court is well aware, late filings result in unnecessary delay. Mr. Robinson does not dispute the law on public access to his criminal proceedings. He anticipates that many, if not most, of the proceedings and filings in this case will be public. When necessary, Mr. Robinson will seek the appropriate remedies in order to protect his constitutional and other interests. Subject to the procedures outlined in Utah Rule of Judicial Administration 4-202, of course. He will continue to abide by any additional orders of this court and governing notice. Angel, up, and over. So you hold on. Look. Yeah, and this is the hot button issue that I'm kind of torn on most days. Like, my opinions are rarely one way or the other all the time. Not only am I entitled to change my mind, it's a case by case basis. Mr. Robinson, of course, he will also continue to abide by any additional orders of this court governing notice to the media and motions to classify or close proceedings. Ugh. And I just checked; they are still in closed session. They should do trial by combat. Oh my god! Way to bring that up. Hold on, I'm gonna mute myself for just a second so that I can restart this. Court TV is currently in the Amber Alert murder trial, New Hampshire versus Dustin Duran. Hi. Sentencing. I have no idea about that case. Will I help you? Yeah. Girl, you got to find a different game because there. You either got to find a different game or learn how to do it because I can't do that every time. I'm going over to Spawn's channel in a bit. Yeah, we're gonna keep reading these documents, and depending on how long this takes, we might. I don't know. I knew it was gonna be a partially closed hearing, but I didn't think it would be as long as it is for a closed hearing. So, but have a good one. If you don't come back, I'll see you on the next one. Okay. Mr. Robinson does not object to reclassifying a redacted transcript and audio from the October 24th hearing as public. With the full transcript remaining in the private record. So it's all his attorneys. In addition to the late filing, media seeks the opportunity for supplemental brief after the closure hearing, prolonged decision on this matter, permitting further briefing in this court's discretion. However, Mr. Robinson believes that additional briefing will not facilitate a timely classification determination and may result in further delay of substantive litigation. I mean, so that was kind of what they're arguing about in this. I see where the defense is coming from. I do. Because they in Utah, and I didn't know that about Utah, that when something is sealed, the judge, it's sealed to everybody, including the parties, which I find odd. However, with that being said, that's why they filed the motion to unclassify it, so that they could get a copy, because you can't do anything, appeal any issue, if you don't have a transcript of the hearing. Just saying. He left. He's got his own, he's doing a members only stream in a little while. So it's a good situation. So he's not here to get fired up. All right. This one's still on a court break. We will and I wish I had access to the whole filing, or the whole docket. She does put a lot of stuff in here. If you ever want to see what she's doing, I highly suggest and I'm trying to make sure that I can see this screen. So if it comes back up, I can get a quick switch over. Because if I can't see it, then it's a problem. But this is her Discord, or not her Discord, her Substack. I highly suggest going over there and giving her a follow, because it's legal color commentary with Andrea Burkhart. She's awesome. She has everything that she could. She even says not obtained, you don't need a return of electronic documents. We all need to help Spawn Trooper with his streaming schedule timing. Well, it is what it is. And that's the thing. There's a lot of stuff going on right now. There's a lot of people streaming right now. There's a lot of interesting trials going on. There's a lot of hearings. There's just a lot of stuff. But while we are looking, we are going to we're going to see what's in the yeah, she's awesome. I would love the opportunity to talk to her and just pick her brain one day, because she followed all the Brian Koberger stuff, because she's close. That was what made it easier for her, but her coverage on that was like beyond anybody else's. However, we are going to continue to look for documents. Y'all are going to help me. This is becoming a research channel until the case comes back. So this is Germany Atkins. This is Ethan Pritchard, one of the people accused of attempting to unalive Ethan Pritchard, the Florida State football player. Ooh. Oh. Nope, they're back to the Amber Alert murder sentencing. I have no idea about this case, but we are going to watch it because it sounds interesting.
Attorneys are expected to give their closing arguments tomorrow, beginning in the morning. Now, Walsh stands accused of killing and dismembering his wife, Anna, back on New Year's Eve day in 2023. Now, he told the court just earlier today that he will not be testifying in his own defense.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Now, no other defense witnesses were called, so the judge sent the jury home for the day, and the attorneys, they worked to finalize jury instructions. Again, we will bring you closing arguments in the Brian Walsh murder trial tomorrow morning, right here, of course, on Court TV. All right, we're going to head back now to New Hampshire, where convicted killer Dustin Duren is being sentenced today in the Amber Alert murder trial. The 38-year-old father was found guilty earlier this year fatally shooting his girlfriend, Caitlin Knopfziger, before kidnapping their 2 young children. Now, we just heard several impact statements from friends and family of Dustin Duren. I want to get back into court now, where the defense is actually speaking to the court.
This is a tragic case, and no sentence that the court can impose will undo this tragic situation or make Ms. Knopfziger's family whole. The court has a difficult task in imposing sentence and in balancing the aims of sentencing. As the court undertakes that difficult task, we ask the court to consider Mr. Duren's history and background, his service to our country, and how that service...
I'm sorry. I hate when people do that. Well, I'm a veteran. He's a veteran. It does, making you a veteran, like making you being a vet, does not abstain you from being an asshole. Like, it does not put you above the law. It does not make you a better person than anybody else. Ask me how I know.
Forever changed him. And we also ask that the court consider the particular circumstances and context of this case. Mr. Duren is respectfully requesting that the court impose a sentence of 25 years to life at the New Hampshire State Prison on 1 count of second-degree murder, with additional suspended time on the reckless conduct and endangering counts. We ask that the court authorize that Mr. Duren can receive earned time reductions for completion of programming at the prison. And we further ask that Mr. Duren be ordered to comply with any Minnesota family court orders regarding contact with his daughters. As we discuss why the court should adopt our proposed sentence, I'm going to try not to rehash what's in our sentencing memorandum. We'll start by first talking about the aims of sentencing. We'll then talk a little bit about Mr. Duren as a person. I'll address some of the points made in the state's sentencing memo and in his argument today. Several of Mr. Duren's friends and family will address the court, and Attorney Kinney will read statements from some friends and family who are not here. We'll conclude by talking a little bit about the United States Supreme Court case, Porter versus McCollum. Starting first with the aims of sentencing. The defense's proposal balances the aims of sentencing: punishment, deterrence, and rehabilitation. 25 years in prison is punishment. It is decades of incarceration, decades without freedom or autonomy.
I'm sorry. Your client is convicted now of unaliving someone 31 years old and a mother of 2 children. So he took away her rest of her life, which I damn sure know would probably be more than 25 years. And he also took away both parents now of his children, which is definitely going to be more than 25 years. I hate when defense attorneys do this. Hate it. It drives me up a wall.
It is a serious punishment for a serious crime. If the court imposes Mr. Duren's requested sentence, he will first be eligible for parole right around his 62nd birthday.
Not my problem.
He will miss his daughters' entire childhoods. He will miss their high school graduations, their college graduations, and their first jobs.
So will their mom.
He will not be present for many of the major milestones of their lives.
So will their mom.
He will not have the opportunity to spend time with his parents in their retirement, and
Neither
he will
will
miss
their
the
mom.
childhoods of his nieces and nephews.
Neither will she. Sorry, this is my response to all of
25
this.
years in prison will punish Mr. Duren for the crime for which he has been convicted, and it will forever change his life. but it will allow for a possibility of redemption, for a possibility of parole. If the court imposed the state's recommended sentence, Mr. Duren would not be eligible for parole until he was about 82 years old.
Not my problem.
This is a de facto life sentence. The Social Security.
I'm sorry. The average age in this country, life expectancy for men is 72. You need to at least be in prison until the de facto life expectancy for your gender. No.
The administration.
I believe he shot her.
Publishes actuarial life tables, which provide statistical analysis of the average remaining number of years expected prior to death for a person. According to the Social Security's actuarial life tables, if the state's recommended sentence is imposed, we should expect that Mr. Duren will die in prison.
Good.
The state's proposal is a de facto life sentence. And if the legislature was of the opinion that all murder cases should result in life imprisonment, it would dictate mandatory life sentences for second-degree murder like it has for first-degree murder. The legislature has not imposed such a sentencing structure for second-degree murder cases, and there is no requirement that this court impose a sentence that functions as a life sentence, and this court should not impose a sentence that functions as a life sentence. I understand that the state attempted to do some different calculations related to parole dates, but I think that those dates that the state provided obfuscate the reality. The reality is that Mr. Duren will not be eligible to earn the maximum amount of time off at the prison, because many of the ways that you earn time off at the prison are for getting a GED, getting an associate's degree, getting certain certificates in education. And Mr. Duren already has those certificates. He's graduated from high school. He's a decorated military veteran. He has an associate's degree and others.
Stop bringing up the fact that he's a veteran. It doesn't fucking matter. You know, there are people who are veterans who were given the choice, go to jail or go into the military. Like, just because you have been in the military does not make you a better person, does not make you a good person. There are people who literally had to go in the military, or it was either military or jail, and they chose military. Those people are still veterans. I hate when people do that. I hate it. Well, you have to respect me, I'm a vet. I don't have to do fucking shit.
Certificates in his field, and so he won't be eligible to earn that amount of time off. I also think the state's reliance on 651.20 to argue about the length of the sentence that Mr. Duren would serve, is not reliable. 651.20 is extraordinarily unlikely, extraordinarily rare, especially in a case of this type, and the state is not offering to not object to any such reduction in sentence. We have advised Mr. Duren, and Mr. Duren can expect, and this court can expect, that these numbers mean what they say, that 25 years is 25 years, that 45 years is dying in prison.
Not my problem.
And 25 years, Judge, as the sentencing comparisons show, allow the aim of sentencing to be, of punishment to be met. Turning next to deterrence. By ensuring that Mr. Duren has an additional suspended prison sentence hanging over his head, and that if he is paroled, he will be on parole for the rest of his life, this sentence will deter Mr. Duren from committing crimes in the future. He will know that if he commits a crime, he will be in prison longer or go back to prison. And this sentence will also act as a general deterrent for society.
Okay, I know her statement right there. I'm sorry I keep stopping it, but this bitch just she said that'll be a deterrent going back to prison. Well, going to prison generally should be a deterrent to get people to stop committing crimes, but that shit doesn't work.
At large. The message that Mr. Duren's proposed sentence sends is that if you are convicted of murder, you will spend decades in prison. That's general deterrence. In terms of rehabilitation, as I've said, the state's sentence calls for Mr. Duren to die in prison. That is not a sentence that allows for or supports rehabilitation. It is not a sentence that allows Mr. Duren to engage meaningfully with the rehabilitative programming that the prison has to.
So the state didn't want life. The state wanted 50 years, but because of his age, she is arguing, this is defense attorney, that it's a de facto life sentence because of he's already like 38 or something like that. So 50 years in prison would make him essentially a life sentence. And that's what she's trying to argue. I don't think she's being very effective at it, and I have a lot to say about it, but yeah. I don't know anything about this case either. I'm just reading what was done. He was convicted. He unalived the mother, his girlfriend, the mother of his 2 children. One child was 4 and one child was 1. And he then kidnapped the children. So that's how it got the name Amber Alert murder trial, I'm assuming. Yeah, apparently it isn't a general deterrence. It's not. If it was a general deterrence, nobody would be committing crimes at all because everybody would be afraid of going to jail. But jail, especially 3 hots and a cot, is not our deterrence. This woman needs to shut up. She's not being helpful. I mean, I understand she has a job to do, but this is not how I would, like I said, not a lawyer, so my opinion really doesn't mean squat as far as actual facts. It's entertainment value, but this is not how I would argue this.
Offer with the aim of rehabilitating himself for his release. In contrast, the defense's proposed sentence furthers the goals of rehabilitation in 2 major ways. First, it allows him to earn some small amount of time off of his sentence by engaging in programming at the prison and by working to rehabilitate himself at the prison. And second, it furthers the aims of rehabilitation by allowing him hope. Hope that he will have some period of his life outside of the prison. Hope that he will be able to be reunited with his family outside the prison walls. Hope that if he works hard to rehabilitate himself, that hard work and that rehabilitation will pay off, and that he ought to take the time at the prison seriously because there's a chance for him to experience life afterwards. The defense's proposed sentence meets the aims of sentencing in this particular case. Turning now to Mr. Duren himself. The court heard from Mr. Duren at trial and had the opportunity to review our sentencing memo and its attachments, including statements from some of Mr. Duren's loved ones.
He's a
And what I
defense
hope
attorney.
those materials make clear is that Mr. Duren loves his children more than anything. His friends and family all reference, and I think both his initial statements to police and his testimony at trial both demonstrate that he is an incredibly loving father, that his children mean everything to him.
If you are an incredibly loving father, you would not have unalived your child's mother or your children's mother. Hate for someone aside, you don't claim to love somebody and then unalive somebody that they love. That's not how that works. Oh, yeah, he loved them so much, he took their mother's life. Yeah.
And that his life forever changed and he gained purpose when he became a father.
Well, apparently it didn't.
I'm going to play for the court a piece of music that Mr. Duren composed that reflects his unyielding love for his children.
Okay, I can't.
Mr. Duren is a musician, a composer, and an audio engineer. And for most of his life, Mr. Duren has felt that words have failed him, and he's preferred to express himself through music. He feels that music is the language of the soul, and he wrote a piece of orchestral music in 2021 about his feelings during Miss Nafziger's pregnancy the birth of their first child, and the first year of Elwyn's life. This piece of music, which is entitled First Morning, is a tribute to the love that he feels for his family. It's Exhibit A in case lines, Judge.
I'm
of a
sorry, I
child.
can't listen to that.
That's not about the children. That's about you, as far as I'm concerned. But at the end of the day, he can't add on that child endangerment to whatever sentence he imposes. I think this is the kind of case that warrants exactly that. Your thoughts?
I don't think.
Yes, he can add it on. It can be consecutive to the second-degree murder conviction. And I do think that the defense is just trying to play out and for the judge, the considerations that were going through her client's mind at the time, right? Like, I love my kids. I want to be with my kids. I've got to protect my kids. And that's what they postured during the trial. And so you see that kind of remanifesting here at sentencing. But I don't disagree that this is traumatizing for a child to, have seen this, remember it, even reenact it. According to one of the victim impact statements, the child has talked about what happened in front of her. And I think that that is really going to be impactful for the court when considering what to do.
Yeah, again, all those other mitigating factors taken into account, the way he did it still creates real serious considerations for this judge. All right, Joanna, stand by. We're going to take a break here. When we come back, we'll have more sentencing, more of that sentencing hearing for Dustin Duren. So keep it here on Court TV, your front row seat to justice.
A big ass Peloton thing. Let's go live. So the things on Court TV that you see when other things are on break and they play random court cases across the country, I'm like, I just can't. Like, that is what I'm sure. I thought her first sentence was going to be, for fuck's sake. I can't, I don't really know this case either. Except what I'm seeing here, but she didn't strike me to be that he didn't do it in self-defense or defense of his children. Like, there's a case to be made if hypothetically she was in the middle of doing something awful to the children and he attacked her to defend his children. That's self-defense. That could be a self-defense claim. That's not what happened here. Based on what I'm seeing and the pictures, and that's not what happened. It just seems
Welcome back to Court TV Live. I'm Michael Ayala. Let's head back now to New Hampshire for more of today's sentencing hearing for Dustin Duren. Duren was convicted back in October of murdering the mother of his children, Caitlin Knopfziger. And investigators say that Duren then took off with the couple's two children, prompting an Amber Alert.
That's the
problem. Back into the courtroom now. The defense attorney is addressing the court and asking the judge for leniency.
Details Mr. Duren's military service and why it calls for leniency in sentencing. We've also submitted a report.
I believe he was charged with child endangerment as well, which is
connected PTSD impacted his actions and his decision making on February 29th.
If you have PTSD, you need to be in treatment. I know plenty of people with PTSD that don't treat other people like crap.
That Mr. Duren, at a very young age, stood up and volunteered to serve his country, that he served his country with honor and distinction, including service in Iraq, and that he will forever bear the psychological scars that his military service caused. The Veterans Administration has found that Mr. Duren has an 80% disability rating, meaning that
and I'm 90. What's your point?
He was 80% disabled as a result of his military service, and 70% total of which is from his service-connected PTSD. And I won't go into too much more detail about his military service because it is covered in the military mitigation report that we submitted. The next slide that I'm showing shows photos.
Look at what his testimony says on the side. Grabbed a pew-pew when he claimed that she crossed a line when they struggled over a crying child. I can understand a crying child being stressful, I can understand being stressed out with PTSD while dealing with a crying child. I know somebody who has done that, and they never unalived me or my child. Just a thought.
And the group photo at the bottom left is from Merging Vets and Players, a nonprofit veteran support organization with which Mr. Duren was extensively involved. The next couple of slides, Judge, show Mr. Duren in the role that he loves most, his role as a father.
Me too. I would really like to get that last 10%, but it's never going to happen. Where's your glove? Oh, you got the both at the same time. Bye. Okay.
And this exhibit ends with a photo of Mr. Duren.
Sometimes you just gotta let the child cry if it means that you're not going to be able to handle it.
The worst thing
You just
that
got
we
to
have
set the
ever
child
done.
down and walk away for a
We
second.
are all more than one day and one action. In imposing a sentence, we ask the court to consider Mr. Duren as a whole person, a person who is capable of redemption and rehabilitation. Turning to the state's sentencing memorandum and sentencing comparisons. The state attempted to characterize the events in this case in a certain way in its sentencing memorandum, to insist that Mr. Duren acted out of anger or control. We don't agree with the state's interpretation of why this happened. The court heard Mr. Duren's testimony, that Mr. Duren reacted when he heard his child scream, and the court should credit that testimony. We acknowledge that the jury found that Mr. Duren's actions were not justified under the law, but that does not mean that the state's assertions about Mr. Duren's motives or mental state are true.
This guy back here,
They are not.
just watch his face.
We ask that the court consider the context of this case, the context that led to the court instructing the jury on defense of others when imposing sentence. We also ask that the court consider the connection between Mr. Duren's PTSD and the events of this case. The state said in its memo that there is no connection between Mr. Duren's PTSD and this case. And I think they said in their argument that he didn't rely on PTSD at trial, and so the court can't rely on it now. But that statement is incorrect and it's wrong. And I think, again, it doesn't cover the reality of why and how.
I took a guess. I had no idea how old he was. I took a guess that he was 38. That's a rough looking 38. Just saying, I'm 40. I'm not so like spring chicken myself, but like that's a rough 38. Marine Corps vet. That
Ended up presenting the evidence that we did at trial. There was extensive pretrial litigation that the state initiated focused on the admissibility of Dr. Pittman's testimony at trial. And the rulings that the court made have an impact in how someone chooses to go forward. I think the state's argument that because we didn't rely on or explain the connection between PTSD and the events of this case at trial is legally incorrect. It's burden shifting. It's punishing Mr. Duren for exercising his constitutional rights. And the state fought hard to prevent us from presenting Dr. Pittman's testimony. And so it cannot and should not use the fact that we were unable to present Dr. Pittman's full testimony against Mr. Duren now. The court can and should consider Dr. Pittman's testimony, I apologize, his expert report when determining what sentence to impose. That report has been submitted with our sentencing memorandum. There's an opinion from an expert, a highly trained and qualified doctor, himself a veteran, who works at Harvard Medical Center and Mass General, that outlines the links between Mr. Duren's PTSD and this case. And the court can and should consider this as extensive mitigation information when imposing sentence.
I know I've said it before, and I don't mean to be a dead horse, but I know plenty of people with PTSD.
Right.
They don't go unaliving
With us,
people.
criminal defense attorney Joanna Nieves. Joanna, interesting dilemma there for the judge in this crime.
And I'm going to mute this so I don't get copyright struck. But like, they don't have a problem with court feeds, but like their commentary, I don't want to take that chance. It's just one of those situations where it's like your PTSD really doesn't have a lot to do with unaliving someone, because you can have severe PTSD. The people that I know that had the most severe PTSD, the only people that they wanted to unalive were themselves. Yes, PTSD can cause you to be, but over a child screaming, you have two children, over a child crying. Like, what would prompt you to? I can't think of anything PTSD wise, and I'm not a doctor. I'm not diagnosing. I'm not remote diagnosing. I am. It's one thing to have it, and yes, you have it. Acknowledge that you have it, and try to be a good person. It's another thing. I just feel like they're using it as an excuse. Like, I cannot be held liable for my actions because I have PTSD. Like, that's what I can't stand, when people use their mental health as like a shield. It just like when people use their military service as a shield. It's just not my, like, yes, y'all know that I'm a vet, but I don't sit here and go, "Oh, I'm a veteran, you can't talk shit about me." Huh? Like, no. Being a vet doesn't make me any better than anybody else. It doesn't give me any more rights than anybody else. It paid for my college. It paid for my college and gave me life experience. Does it mean that I have a lot more life experience than some other people? Yes. And I have some insights that other people don't have? Yes, but that does not make me a better person. Just like someone going over to someone else's channel because they're a lawyer. I'm not a lawyer. That doesn't make my channel worse or better. It just makes it different. It's like if lawyers try to talk about medical stuff, it's out of their element. It's not what their expertise or their college education is in. So of course it's going to be different. Not bad, just different. I think that it was their baby. I think it was their youngest child, who was 1. So I think it was she was just crying. But that's all I've been able to discern. It is 3:41. We will see if this. Okay. They are a
portion of that hearing. We're going to take you back into court. Keep it here. We'll be right back.
Perfect. So hopefully soon.
Disappearance of Anna Walsh.
Her husband now
They're
charged
using the
with her
crying child as an excuse, and yeah, I just can't. It's one thing to. I just don't like when people make excuses for bad behavior. You made bad behavior because you made a mistake. Shit happens. Sometimes shit really bad happens, but it's not necessarily because you have any particular issue. A lot of the times it's because you did something stupid, because you acted on emotion when you shouldn't have. And yes, PTSD can cause you to act on emotion. Don't come at me. But it's when people hide behind it and use it as an excuse instead of taking responsibility for the fact that I would have felt a little bad for him or used the PTSD as an excuse or as a defense if he would have shot her and then went, "Oh crap, what did I do?" I had an episode and I did it and called the cops right away. But no, he chose to run, which is a rational decision. He chose to take his two children by you. It's not like, hey, he said, hey, get in the car. He had to take these two children and put them in car seats. Remember that. These children were 4 and 1. So it takes time. If you've ever had kids, you know, it takes time to get the children into car seats. And you have to take care of the 1-year-old first. The 4-year-old can probably get themselves into the car seat. But will they listen? And after they just witnessed something, are they going to be cooperative? Are they going to be crying? Yeah, something really bad went on here and you're using your children. And it's like, I hope he gets, I will let you guys know what he ends up getting. But I'm hoping it's 50 years or 44 years and 11 months. I've never used disability for an excuse. As a licensed clinical social worker, I've never allowed clients to use an excuse either. And I use my depression as an excuse for why I'm a procrastinator, because it takes so much energy to get stuff done, but that's not exactly bad behavior. That's me not taking care of my shit. And like I got the other stuff done today. I did get it uploaded, so it should be released. And I am in the process of making a PDF. So if you watch that video on my other channel, and you see because it didn't exactly show the exercises on screen like I usually do, because I'm trying something different. I have a PDF. I'm in the process of making it. It should be up tomorrow. Yeah. Me too. I've learned mostly use my disassociation to advantage in emergency and unpleasant situations. That's a good. That's insight into yourself. That's having a good insight into yourself. So hopefully this Tyler Robinson hearing, I knew it was going to be partially closed. I just didn't think it was going to be closed for that long. The other channel is up to 225. So we're getting there. I do have more back to the Amber Alert. I feel like they keep saying they're going to go back to the Charlie Kirk thing, and then it's just not. Oh, estranged husband charged with murder in 2001 cold case. Jesus. All right. We are going to oh, okay. We're just not going to get into that and watch that one, because I'm going to get hooked on another case, and I got enough to find me hooked on right now. So we're going to go back to this. This is, so if you've followed me through my coverage of the Florida State football player, this is his notice of court date, 1/8/26. Germany Atkins is one of the people accused of shooting him. This is what I do. I go through these documents and I write stuff in calendars. Because I have to write stuff in calendars to keep it all straight. So I have my court hearing here calendar. Hey, Timothy. That's not an excuse. It's being honest. You're depressed sometimes. Well, it's not even that. It's like, because ever since I've been using the sauna blanket, I've been sleeping better, which is helping me be more productive because I'm actually sleeping at night. What a freaking concept that is. Although Spawn messaged me this morning and asked me if I could hop into a Discord server and talk for a little bit about his stream today and stuff. later early this morning, and it happened to be before my alarm went off, and I'm like, I am not moving until my alarm goes off. I was like, I will talk to you later. I'm glad you're home safe. But he has she's still going. Do we want to listen to these arguments? Defense attorney asked for leniency, or is this going to give us a headache? Because her voice is like, I understand she has a job to do, but I'm finding myself agreeing more and more with the state's attorneys these days, and that's a problem.
That this has occurred. Mr. Duran has never denied.
Oh, he did claim self-defense because she was going to kidnap their
Called
kids.
his parents and told them, knowing that they would call the police. He waived his Miranda rights and told the police what had happened. He testified at trial about what had happened. He has never denied what has happened. He is devastated and horrified.
Sorry.
Turning to sentence comparisons, as both sides have acknowledged, every case is different. Every person is different. Both sides can point to cases where the sentences imposed were similar to the sentences that they were requesting in this case, or try to distinguish this case from sentencing comparisons that were provided. With those caveats, I'm not going to go through the state's sentencing comparisons one by one and explain how they're different. I think you can see that in the state sentencing memorandum. But I do just want to note for the court that there are some reasons that the sentence that Jesse Sullivan received is not an appropriate sentence for the court to consider. And Attorney Kinney and I have ethical obligations that prevent us from saying more, but Attorney Duran represented the state on the case and is aware of the irregularity in that case and how that particular sentence was reached.
See ya.
I'd also like to highlight two of the cases in our memo, Tyrese Harris and Dylan Sleeper. Both are cases in which the jury was instructed on both self-defense and manslaughter, but ultimately the defendant was convicted of second-degree murder. Neither of those defendants was a veteran with service-connected PTSD. Service-connected PTSD that an expert has opined played a role in the events of that evening. Mr. Sleeper had a prior criminal record, unlike Mr. Duran, who has no criminal record. And both the Harris and Sleeper cases are cases in which the defendant was sentenced to 25 years to life after trial. The sentences that those defendants received are the same as the sentence we asked the court to impose, and they demonstrate that the sentence the defense is requesting is a proportionate sentence in a case of this type. Judge, we'd like to give the opportunity for some of Dustin's friends and family the opportunity to speak. We submitted multiple letters along with our sentencing memo, and there are additional letters we've received since submitting our sentencing memo that have been uploaded to case lines. Attorney Kinney will read those letters, but I'd also ask that the court accept as exhibits all of the documents and materials that have been filed in case lines for this hearing, just for the purposes of making sure we have a complete and accurate record.
Certainly.
All right, so now it looks like they're going to read onto the record some letters that they want the judge to hear. Let's bring in criminal defense attorney Joanna Nieves. Joanna, we're at the point now where the judge is ultimately going to have to make a decision.
I don't know how I feel about this. He said that she was trying to kidnap the kids. Well, stop her from leaving and call the cops. Don't unalive her and then run with the kids. What's your end game there? Like, I just, something's not adding up. Even in a PTSD brain, something is not adding up. And I think it's the fact that it was intentional. Like, he didn't do this as an accident. It wasn't self-defense. Obviously, the jury only took 3 hours to deliberate in this case, according to the little sidebar notes. So they only took 3 hours. that's usually not a good sign. You did not have a good case. Your lawyers did not put on a good case. I got nothing. Like, I got nothing good to say about this. This is one of those situations where you just look and you're just like, why? Why did this happen? Why? This happened for no reason at all. And now that it's getting dark, I have to turn on this light. Here we go. I don't know. That's another good question. I did not watch this trial. This is just the sentencing. However, it is 1-8. Oh, Jaden 9:15. So the case management conference for our felony attempted possession of a controlled substance with intent to sell. The person who is accused of being involved in the Ethan Pritchard shooting, who is not being charged with an unaliving charge, has a status conference on 1/8 at 1 o'clock or 1:30. One of the other defendants has a status hearing that same day at 9:15 a.m. So that should be a busy day. I hope those will be televised. I doubt they will, but it is Florida, so you never know. 13:30. What's his name? Germany Atkins. Atkins. Well, let's see if there's any new documents in this case. Sorry, the little's yelling at me from the this suitcase murder is Samsonite Sarah. Oh, what's up, Angel? Girl, you have lip gloss all over. Come here. Come here. All of these are hard in their own way. Jaden. Yeah. Oh, thank you. Thank you for putting it back. Interesting things are happening in this house today, and I don't know why. Hopefully this Tyler Robinson hearing will be back. I don't mind just doing a research stream and talking to you guys. It's kind of fun. However, I'm kind of curious to see what is going to come of this Tyler Robinson hearing. State cases. Florida. Where's my Florida folder? One, Colin Griffith. Pritchard. All right. Bodison. I had to think of this kid's last name. Public inquiry on Gadsden Clerk is another easy one to, like, look how easy this is. Like, all I did was put in their name. And it was so easy to find. Attempted first degree unaliving on 8/31. Case management, 9:15 a.m. There was nothing. However, we are going to look at Ethan. Nothing's been filed in this in the civil complaint either. Well, that's one less case I gotta research after the stream's over. You know, I have my list of, like, sometimes ChatGPT can look up stuff on, like, Google for me and see if there's any, like, stuff in the news, but sometimes, well, most of the time, it can't look up county clerk websites, which would be very helpful because that's what takes a while.
Welcome back to Court TV Live. I'm Ashley Wilcox.
And I'm Michael Ayala. We're both here today giving you your front row seat to justice. And we are in New Hampshire, where a convicted.
Yeah, right here. Small boat 90 whimsical. Yeah, crazy witches be scary. Not gonna lie, guys. Quit sticking it in crazy. Yeah. And this right here is like, Angie, we know none of us followed this case at all. We're just being judgy, waiting on Tyler Robinson hearing to open back up. Oh.
But Duren took the stand during the trial where he claimed he shot in self-defense after Knopfziger threatened to kidnap the kids unless he agreed to pay her money that he didn't have.
Now, earlier today, we heard from family and friends of Caitlin, the victim in this case. Now we're going to hear from Duren's relatives. I want to get you back into court where his cousins.
That doesn't add up. That does not add up. Like, that story just makes no sense.
I have known Dustin my entire life, that being 37 years. I would consider Dustin to be one of my closest cousins. Dustin and I grew up camping together with our families, attending holiday events together, and as adults, meeting up whenever I was in Las Vegas so our children could play together and we could catch up. I am aware of the crime that Dustin has committed. Dustin was raised to be a very well-rounded and respectful person.
Apparently someone
Dustin
failed.
is extremely intelligent, a very kind and loving person, a hard worker who followed his dreams, and over everything is an amazing, loving, and caring father. Dustin followed his...
I have a really, really hard time with people saying that someone's an amazing parent when they unalived the other parent. Because whether you have a problem with that person or not, those are your kid's parent. That's your kid's parent. Like, I have a very hard time with anybody who's like, well, they're such a loving father. If they were a loving father, they wouldn't have took the other parent away.
His dreams out to Las Vegas. Once Dustin became a father, being a father was absolutely everything he wanted and needed in his life. Dustin was someone you could call whenever you needed advice, to be picked up, cheered up, or just a little motivation. Dustin did everything in his life to provide the absolute best life for his daughters. Dustin's sentencing would greatly impact his relationship with his daughters and also our family dynamic. We cannot.
So did unaliving their mother.
Be able to see him be the amazing father that he has been to those girls.
Welcome to trial coverage with
Squid. It would
Squid.
also devastate our family to not be able to spend holidays with him or vacations with him ever again. It would be detrimental to our family if he was sentenced harshly. We pray that you can sympathize with Dustin and his family during this extremely difficult time. We are asking for leniency, so someday Dustin and his beautiful daughters will be reunited, and he will be granted another chance to be their everything. To be able to give Dustin the opportunity to see his girls graduate high school, go to prom, graduate college, get married, and hopefully one day be a grandfather to their babies would be the ultimate blessing for not only Dustin, but our entire family. We all want nothing more than to see that happen. I appreciate your time reading this, and I am willing to give you more information about my relationship with Dustin or his character. Please feel free to reach out to me at any time with any questions. Thank you so much.
Thank you.
I do.
Dear Honorable Judge Frizzell, I am
Where's
writing this letter for leniency regarding Dustin Duren. My name is Devin Gomez, and I served with Dustin in the United States Marine Corps from 2005 to 2009. Upon hearing what a heinous crime he had committed, I could scarcely believe the charges. Second-degree murder of his significant other, Caitlin Knopfziger. What a horrible shame, I thought. This hardly seems becoming of the honorable, humble, humorous, and happy Marine Iraqi war veteran that I knew and so proudly served with. To my dismay and disbelief through watching the trial, I sunk to find that the unfathomable news was in fact confirmed. This troubles me deeply because Duren was an exemplary figure to look up to and work with while serving. Always great with mentoring, first to lend a hand and lead by example, talented with a gift for music that he would often demonstrate at gatherings that would uplift his comrades. He continued living an honorable life, clean record, loving family till he was nearly 40. Then one inexcusable and dreadful moment will lead to the ruin of an otherwise distinguished and well-to-do man. I believe if this dreadful occurrence could happen to Dustin, then it could happen to anybody. It pains me that this one moment of darkness and mental deterioration will lead to a long, if not life imprisonment for my good friend and otherwise.
Actions have consequences. Actions have consequences. When you take somebody else's life, don't ever expect to be free.
Command encourage us to be ready killers should the need to defend our country and those we love should arise. Punishment should be handed to anyone who recklessly takes the life of another. But is justice an eye for an eye? Does it require to
Yes.
take his life through imprisonment to justify the life he took?
Yes.
This takes somebody of high regard and honorable motives such as yourself to decide upon sentencing. I personally believe that to rot in prison is a far worse punishment than death. I also
Good.
believe that given the chance and hope that there will be time to reconcile after punishment, Dustin would be able to spend much remaining time helping and inspiring those around him as he did in his first 38 years of life. I hope that there is a small chance of a lighter sentence for Dustin Duren. Writing this letter is the least I could do for my brother in arms. I certainly wish I could do more because I know he would do all in his power for me. One irrevocable moment in life should not condemn us to the worst punishment. Dustin is not a violent man with a murderous intent. He was a shining example of patriotism, voluntarily standing proud to protect Americans' freedom in a time of war, until one disastrous moment, fueled by his confirmed wartime-related PTSD, caused him to do the unthinkable and lose his freedom. Thank you very much for your time, Your Honor. I wish you the best in life and decisions that weigh heavily on your shoulders. Respectfully, Devin R. Gomez.
Thank you.
Yeah, I'm sorry. I was in from 2004 to 2009.
Dear Judge Frizzell, thank you for
20 years
taking the
ago.
time to read this letter. My name is Timothy Duren, and I am the uncle of Dustin Duren, who is before you for sentencing. I write with full respect for this court and full awareness of the gravity of the offense. I am not attempting to diminish the seriousness of what occurred. Instead, I hope to provide insight into Dustin as a person beyond this tragic situation and to respectfully ask the court to consider some measure of leniency. I have known Dustin his entire life. Despite the circumstances that bring him before you, I have always known him to be someone capable of kindness, loyalty, and responsibility. What has stood out most throughout his difficult time is the deep remorse he has expressed. From every conversation, it is clear that he carries profound regret for his actions and the impact they have had on everyone involved. Since his arrest, Dustin has taken meaningful steps to address his behavior and rebuild himself in a healthier direction. He has engaged in counseling and has shown a genuine desire to understand the root of his actions and to take accountability for them. I believe these efforts reflect a sincere commitment to change. One of the most important parts of Dustin's life has always been his children. He loves them deeply and has remained dedicated to them even through this difficult period. I know that being separated from them has weighed heavily on him and has motivated him to better himself so that he can one day be the father they deserve. His children are young and still need their father's presence, guidance, and support in whatever capacity the court ultimately allows. Your Honor, I respectfully ask that you consider a sentence that recognizes Dustin's ability and his desire to continue the hard work of rehabilitation.
And I appreciate those of you hanging out with me for this hearing that was closed longer than we thought it was going to be, and we're just watching whatever court TV is showing us, watching me go off on some defense attorneys and some letters. This is how I cover a case when I'm covering trials. I will talk to the attorneys like they can hear me. I will talk to the family members, the witnesses, like I am in the room with them and they can hear me and they care what I say. Just like I talk to the TV when sports are on, like the quarterback or the coach can hear me. I do the same thing with trials. It can be quite entertaining at times. It's not the most creative, and I try not to talk over people. I will mute them, pause it, interrupt. But this is how I cover a trial. I will just give my commentary when I damn well please and talk back to them like with all snark involved. And hey Roy, how are you? Tyler Robinson's hearing is closed right now. It's been closed for the last hour. In about 10 minutes, if it doesn't open back up, I am going to go because it's been over 2 hours. I'm checking cases right now. Your fun's good. That helps in the quiet times. I am checking other cases, such as there is this that we will go over sometime. It's I have different things. This is a motion to dismiss the civil complaint from one of the defendants in the Ethan Pritchard. Ethan Pritchard is the Florida State football player that was attempted to be unalived. He did survive, and has filed a civil suit against the apartment complexes where the people lived and where it happened. So with that being said, we will cover that probably Monday. We got a lot on the docket. I still have not heard back from the court clerk or anybody involving documents for the Rebecca Park case. That is the case out of Michigan. If I don't hear anything by today, I will just cover it tomorrow and we will just go over what the case is about. I wonder if Duran is a cellar dweller in his mom's house, given that he's a musician and a video game guy, and he's 80% service connected, which means he gets 2,200. Well, with 2 children. Hold on. VA disability rates. And he's currently still getting that money while he is incarcerated, I believe. This is 2026's numbers, so forgive me if this is not accurate from this year. I am not 80%. I don't know what 80% is for 2025. Why is it? Benefits ratings. There we go. Well, I'm not sure. I would have to look into that, but until he was convicted, he was probably still receiving it. So until he was convicted, he was probably still receiving it. But oh, this is the BS that is the VA's website. Explore VA disability benefits today. Compensation. View your disability. Oh, I don't want to view my disability ratings. I mean, if anybody wants to view my disability ratings, I can. I'm 100% service connected. I'm 90. And I currently get 24. File for increased disability. Oh, that would be something, wouldn't it? This is where the VA's website, this is one of the reasons I hate VA medicine. This fucking website. I can never find anything on this damn website. Ever. VA disability payment history. I don't want my payment history. I know what my payment history is. I want the actual manage benefits. I don't want a. Why is the VA's website so damn difficult? Why? So I'm gonna see what they. Motion review hearing for Tyler Robinson. They keep saying soon, but they never. The soon is not anytime soon. But if you want to watch closing arguments tonight at 8, 100% with a spouse is just under 4,300. I'm at Projected 2026 disability. Why is this so damn hard? Oh, here we go. Veteran alone. This is 2026 projected. Yeah. Well, that's not accurate. I have children. Veteran and one child. So he has veteran and two child because he is not married. So all right. 80% veteran with one child. Veteran and one child is $22.19. So he was probably getting over $2,000 a month until he was convicted. Because this is Kirk $24.94. What am I getting right now? So veteran and spouse. For veteran and spouse is 100% with a spouse. $41.58. I don't know when this was actually happening. But let's see. Still nothing in Tyler Robinson. If there's nothing, I think this whole hearing is going to be closed. I don't think anything is actually going to be open because it's been over 2 hours. It's been 2 hours and 20 minutes. So, yeah. Oh, I guarantee it. What I should have done is had a second stream set up, and I should just have said, hey guys, I will see you later. This is obviously not coming back anytime soon. And then when it went live, just hit that second channel. But it's so weird. Why is and even getting your VA compensation, like it's so hard to like find anything. Like the VA makes it so damn hard to do anything. County office. Like they send you to website after website after website and you get a whole lot of nowhere. Veteranrating.com. Let's see. I'm trying to actually find the chart and I can't find it. That's the closest I can find is this. So veteran with one child, $24.94. Each additional child. So he was 100% with two children. So $4,085. He was 110 basically. $4,200. He was getting $4,200. I understand a lockup got their payment suspended. Well, I understand when he was that chart. This is 2026 because I'm currently having to check something real quick. And this is what I'm seeing from where is what's his nuts? I play video games too, Roy, but I like needlepoint while listening to YouTube. Stabbing things relaxes me. I don't know. This is something that I never thought about before. Ugh.
I'm my 20th year of pastoring Community Baptist Church in Colebrook, New Hampshire. And for about 15 of those years, I've had the privilege of volunteering at the Coos County Jail, holding Bible studies and offering biblical counseling
Here we
to
go.
inmates as requested. I first met Dustin on May 30th of 2024. Due to the nature of his physical and emotional state, the jail contacted me and requested a visit on his behalf. The jail has allowed me to visit Dustin twice a week and has permitted about 2 hours per visit. Over the 200 plus hours that I have spent with Dustin, he has been respectful, honest, and teachable in every area that we have discussed. As I listened to his story and what he chose to share with me, I sought to engage him where he was at while bringing a perspective based on and oriented to God's Word. He has been most open and transparent with me and has demonstrated himself to be forthright, even when the truth or his thoughts would cast him in a negative light. He has not been afraid to disagree with me or to push back when his views differed from mine, but has always done so in a respectful manner. He is quick to listen and slow to speak. He is consistently pensive and thoughtful in his communication and is not one to respond with haste or void of
Y'all, talking to you about this shit is my therapy. Is how I make it through the day. Because he's being watched, but also if he was really this kind of person that doesn't respond with haste, he wouldn't have unalived somebody. But hey guys, it's 20 after. Mr. Squid will be home soon and I have to figure out how to get dinner on the table if he's even hungry. I'm currently getting 4502 at 100%, which is myself and my wife. My 2026 rates will be 2.8% higher, so I'm not sure how I differ from that chart. Are your children still are they under the age of 23? Because apparently if you have a child, a school age child, under the age of 23, you get, so I don't know. I can't find the actual 2025 rates because I 2025 VA pay chart. Uh-oh. I have not. But I'm looking up 2025. Why is this so damn hard? VA disability pay chart. Georgia. They used to have it on like somebody just sent me a meme or put a meme on our Discord server that says, I found a meme that describes you and our team. It says, fueled by haters. Love it. Squid, ask ChatGPT. Oh, yeah, duh. Hello. Stupid me. My goodness. All of that when I could have asked ChatGPT. Jesus. Let's see. 2025 VA disability pay chart. So there's that. 30 to 60%. 70 to 100. Veteran alone with spouse. Yeah, you must have Roy, you must have your, I don't know, because 100% with spouse is 4,044, according to this. So, I don't know. I don't know. What? I will do that. LED light board. LED light board. Uh spouse and one parent. Spouse and two parents. Where's with one spouse and child? Or with child? No, Jesus. Oh my goodness. 2026 monthly rates with dependents. With spouse and one parent. With spouse, no children or parents. With spouse and two parents. What about no spouse and one child? What about us single bitches? It's probably the clothing allowance that might set you off. Strong coffee and bad decisions. I will look, Gail, and add it to the Amazon list tonight. What about one child, no spouse? It would help budget for next year if I can kind of figure out how much I'm going to be paid. $24.94. That's not awful. That's not 2%. That's not 2.8%. That is not 2.8%. 24, 25. I'm doing math, so bear with me because zero to it. Ooh, suddenly forgot how to do math. Oh wait, that is 2.8%. Well, shit. See ya. Thanks, Snipe Hunter, for hanging out with us. Oh, look. Look. Look it. Remember how I said I was going to go? And then yeah, I do. I do. It's common knowledge. It's not a yeah. And that was just my chat GPT stuff. So like I have nothing to hide on there, and everything on there is common knowledge. And the name on there is not my name. So I'm not doxing myself because that's not my name. It's funny. So I put purposely things that aren't my name on situations like that, so that if they get shown, it's not my name. It's just gonna close the window. I have to go check on my little one though. I will be right back. All right, guys, I am currently making the little toast because that is what she wants for dinner. I tried to take out some sausage stuff that I had in the fridge that I was going to cook, and all I got was no. And she tried to slam the fridge door on me. So it's going to be toast until Daddy gets home and figures out what he wants to eat, if he wants to eat anything. And sometimes, I don't know if anybody who has been a stay-at-home parent has experienced this before, but when she's with me all day long, sometimes she won't eat well for me. But when Daddy gets home and he says, okay, it's time to eat, she's like, okay. You know, I believe Tyler is guilty. I do too. Based on what I've seen, I do too. There's a lot of conspiracy theories, and like I just don't. I know when the brain doesn't get information, the brain has to come up with a story. It's not anybody's fault. It's psychology. And when that happens, um, it just the brain has to come up with something. So, you know, I was watching my local news and said reporting to afford a starter house in the El Paso area would need a job paying $113K annually. Ugh. Yeah. All right. I just heard the toaster pop. I know. I'm going. You want to tell everybody what you're having for dinner? A toast. Toast with what? With Telltale? That's Nutella, for those of you who need a 3-year-old translator. Toast and Telltale. I will be right back. I'm going to go get her toast with Telltale before. I'm getting it. Oh, we got to hurry. Hey, look. And I just checked. I don't have it muted. They just haven't turned on audio yet. Hey. We didn't exactly have a rage quitter, but we had somebody close that said I like this person, so I'm not knocking them at all. We had someone that said they were going to go watch Andrea Burkhart's or Danny's stream because she's a lawyer. I'm like, sorry, I didn't go to law school. My bad. That's how I feel about that. Don't feel bad about toast. I've had the insult of feeding what I cook to the dogs and him eating dog food. Our go-to is she always wants toast with Nutella. Toast with Nutella. And although I wish she would eat more protein and I could get her to eat more protein, I will take what I can get. At the end of the day, a fed kid is better than nothing. No, I'm jealous because I haven't had Gold Star or Skyline since like 2000. Oh, wait. No. 1995 was the last time I had Gold Star chili or Skyline. But I think, yeah, we were more of a Skyline or a Gold Star family in the chili realm, not the other meaning of Gold Star family. Well, thank you for sharing my water. You got to bring me mine so I can plug it in. Bring me my iPad so I can plug it in. You can have that one. You should see the side eye I'm getting right now. Go eat your toast. Girl, you wanted toast. It's not dead anymore. I charged it. Can you do me a favor and bring mommy her iPad? No. But there are a lot of proteins in Nutella. It's not like peanut butter. Generally, I sometimes lay down a layer of peanut butter and then put Nutella on top of it, so we get a little something. But lately, it's like she can find the peanut butter. It's like she can smell it out. But that's okay because Daddy, when her father makes chili, because he makes the chili, I don't, because he's good at it. I'm not. When he serves it to himself, he'll put a spoonful of peanut butter in it. That's him and his brother's thing. They put peanut butter in chili. I don't get it. I don't like it. It's gross. But the little eats it. So when we have chili, she gets extra protein and fat with the peanut butter. And I don't know what the judge is doing and why there's army in the courtroom. But this is just an interesting situation. I just don't know how to explain like this whole situation in general. Hey, I don't do it. I think it's disgusting. He does it. So let's remember that. He does it. I think it's gross. He doesn't put that in the whole pot of chili. Just his individual bowl. But that's what she will eat out of. Who is paying his legal bills? Probably his family. Let's just that guy has a nose on him, but it still ain't as big as somebody's. They go through staging, nudity, dog food, acting like the dogs, disassemble the kitchen. Sandra, thank you so much. Sometimes I'm like, I had to go earlier and I had to go like suddenly because when she walks into her room and you have to walk past our office to get to her bedroom. When she walks into her room with no pants on, I know she needs a diaper change. Like there's very few times that she wants her diaper changed and we're currently fighting the potty training battle right now. She wants to and then she has no desire. She will tell me after she's already peed, but she will not tell me that she has to go pee. So it's like we're just who's paying his legal bills? Hint, they probably have purple hair and a septum piercing. But this has been an interesting stream, and this is what happens with court hearings and trial streams is you got to be flexible. So I've had the opportunity to look up some cases and some documents and found out that a lot of my cases don't have any documents, but Ethan Pritchard does. And I checked my email again, have not heard anything from that court clerk in Michigan. So tomorrow we're probably going to just talk Rebecca Park. Just to for the sake of talking Rebecca Park without documents. Just to kind of get a case overview. And then when I get documents, we'll go through the documents, including the arrest affidavit and what they're being charged with. Yeah. Fill a row, get a toy next time you go to the store. you know, first row has 2 spaces, next row has 4, then 6. What are we talking about? 1:30 PM in Utah, just coming back. Good point. Totally a good point that I just didn't even I thought about that at the start of the session, or the start, that it was the timing there. They probably didn't anticipate this being this long. Hey, hose picker. Oh, no problem. You gotta do what you gotta do. National Guard in fear, Antifa crushing the court. There's been threats. Jeez, isn't it funny? Like, everybody's like, well, their name is Antifa, anti-fascist. They're the most fascist freaking people in the world because, like, they're the one. I don't know. Isn't fascism like one of the parts of fascism is shutting down opposition? I mean, just a thought. Oh, sticker chart. Yeah. Come on. Let's see. And you're fine, hose picker. No need to apologize. That stuff is all what you guys want to do, and I have it there as an option for you guys. It's not a necessity. It's not a requirement. It's just what you're comfortable with. And I give you multiple options of ways to figure things out, and if it works, it works, and if it doesn't, it doesn't. No need to apologize. Yeah, I know that, but I'm just talking to the people who defend that. Oh yeah, the No Kings protests, but then when the government shut down and there was SNAP benefits not being paid out, they were begging the government to pay out benefits. It's like the irony, and people moving to a lot of people supposedly moving to the UK because of Trump. Whatever you feel about Trump, you're right. You're entitled to your opinion. However, there are some things that just logically don't make sense. You are saying no kings, but begging the government for stuff. You are saying no kings, but moving to a country that literally has a king. The logic just, like I said, y'all can vote for whoever you want to. I will never tell anybody who to watch, who to vote for, who they can't talk to, all that stuff, because y'all are adults. But at the same time, the logic, if people can explain to me with like logic why they think certain ways, cool. But when people are like, people are losing their rights, please explain to me how. Because like people that are like, oh, Trump's going to take away like the right to gay marriage, for example. Technically not, because the Supreme Court had the opportunity to and turned down where they would hear a case about gay marriage, and they refused to even hear the case. So there's that. And like, these pesky facts about Trump was the first person to have an openly gay cabinet member in history. Like, there's just things that just don't add up. Like, yeah, whoever you vote for is entirely only your business, but it's the logic of like saying he's this, and it's like, well, the facts don't agree with you. Here we go. I'm wondering what all happened in that, and who's got an attitude now.
We're going back on the record in case 251-403-576, State of Utah versus Tyler James Robinson. I note the presence of counsel that previously entered their appearances. We have come out of the closed session and concluded that business. However, the court became aware of an event that happened before. And my understanding was during the open portion of this hearing
Jay
earlier,
Leno-esque.
that there was a violation of the standing decorum order as it relates to transmission of these proceedings. I want to hear from counsel, and then I will make a ruling concerning that shortly thereafter.
Remember how I said
Thank
something
you.
about a leak?
I'm referring specifically to Rule of Judicial Administration 4-401.01. This gives the court discretion to terminate or suspend electronic media coverage at any time without prior notice, if the judge makes particular findings and that the specific circumstances warrant it. It is our position, the defense position, that there has been a violation of the decorum order. It is our understanding that those live streaming this signed and declared that they would follow the decorum order, and they violated it. So we are requesting a sanction. We believe these court's orders are binding and they need to be respected. We also believe that it threatens my
I will be
client's
right
right
back.
to a fair trial. It's the whole reason we filed a motion in the first place to remove his shackles. It's our understanding that his shackles are visible. It is also our understanding that potentially some audio from counsel table was heard. We are definitely taking more measures on our own to ensure that that does not happen again. But there has also been some filming of computers and materials at counsel's desk. That's entirely inappropriate. And I think everybody in this room will agree that's entirely inappropriate. So we are asking for some remedial measures here. We're asking for it to terminate for today, and we can proceed after that.
Thank you, Ms. Visser. To the state.
Your Honor, the state, as stated earlier, we believe that the court's order was very clear. And if there's been a violation of that order, then we agree that there needs to be some measure taken. We'll leave it to the court to decide the appropriate response to that violation. But we agree that any violation of the court's order needs to be addressed.
Thank you, Mr. Ballard. To the press, attorneys for the press.
Your Honor, Jeff Hunt for the media interveners. This is the first time that we've heard about the violation. We've not had an opportunity to look at the video or investigate the audio or look at the capture of the computers, but filming of the inadvertent filming of the shackles. I did talk to the pool photographer. My understanding is that there was a zoom out shot that did inadvertently show the shackles. That was improper. That was inadvertent. And we apologize for that. They've taken measures to make sure that the pool video that is disseminated to the rest of the pool does not contain any capture of the defendant in the shackles. We can't do anything about the live stream, of course, but we can control what the rest of the video is that we capture and disseminate. So that is being done. The audio for counsel, my understanding is the only audio that they picked up was from counsel's microphones. I don't have any further information about that and whether that's a violation. Filming of the computers is not a violation of the decorum order. If the capture can show the document that counsel is looking at, then that is a potential violation. So I just don't know how much detail the shot is that is of concern to the court. But I'll just say that we reiterated as soon as I heard this from Mr. Ballard with the pool representatives that this is very important to follow to the letter the court's EMC order. They understand their obligations. They take that very seriously. They're not perfect. Mistakes happen. We're trying to correct as much as we can on that. But we think termination is not an appropriate remedy. An admonishment from this court, a reminder that they need to follow to the letter the court's EMC order is appropriate. That's the message that counsel has delivered to the media representatives and the pool operatives. And we think that is the appropriate remedy.
Thank you. Thank you.
I just want to make it clear, we're still receiving messages that shackles can be seen on the live stream as we restart it. So it's still a problem.
Thank you. I appreciate all parties
Guess what?
weighing in on this
Your
important.
fucking client is accused of murdering somebody in public. Like, you know what? It is what it is. And there are people who want him unalived already, and the case hasn't even gotten underway yet. So, like, shackles be damned. Like, sorry, he's in jail. Suck it up, Buttercup.
Matter. And I find that there was a violation of the standing decorum order that was in effect as of October 30th, 2025, based off what's been proffered, as well as the EMC order signed by the court. As previously stated by Ms. Visser, the court does have discretion in determining whether to terminate the broadcast of these proceedings. And again, if there's specific circumstances warrant such action, that the court would need to make findings in order to do so. I find that excluding the cameras from the courtroom would be disproportionate for this hearing. I find that making it very clear, first, that the transmission cannot begin until court is in session and must end as the court ends the session, and cannot be filmed before or after. The filming of, as previously stated in the decorum order and EMC, must be followed to the letter. The sanction for today is that this camera will be relocated away from defense table to where the bailiff is, where Jeff is standing over here. I want to immediately address any possible transmission of shackles, as previously stated by counsel, and remove the possibility of capture of screens of the computers at defense counsel's table as well. In addition, if there's further violations of the standing decorum order, this court does have the right and will exercise termination of broadcast of these proceedings. And I simply want to put all parties on notice, to the press, to all parties, that this court takes this very seriously. While the court believes in openness and transparency, it needs to be balanced with the constitutional rights of all parties in this case. As such, we will take a brief recess to allow the relocation of the camera and to the place indicated by the bailiff, and then we will resume these court proceedings. I am anticipating this take perhaps 5 minutes. All right, and then we'll come back on the record and handle the remaining of this hearing. I appreciate the patience of parties as we move forward. We are trying to do the best.
And that's them, not me. But yeah, like Heather, you make a really good point. It will be a highly publicized trial, but as you've said, there have been other high profile trials. They act like this, they act like this is the only high profile trial. Like, y'all. I disagree. Squid a taser belt would be better than leg restraints. Would you rather see him fall on his face or flop around? Tell the truth. I don't know. I would have liked to see Daryl Brooks in a taser belt. More recesses than we got at grade school. We saw Sarah Boone in her pink handcuffs sitting in the jury box during every hearing. Like we got this. This is not our first rodeo. Like these lawyers, yeah, a high profile trial should be conducted in the same manner as anyone facing the same charges. Exactly. And like, to be perfectly honest with you, I can pretty much guarantee that if anybody from the county wants to see that courtroom, they'll just go there. Most of the people that are watching the pool feed on Court TV or Law and Crime or wherever they're getting it is people that are like me, don't live in Utah, don't live anywhere near Utah, but were a fan of Charlie Kirk. I didn't watch everything he did, and I definitely didn't agree with him on like maybe 25% of his things, but I liked how he went about his business. It's, you know, it's just one of them situations. But while we're waiting for the court to come back, and I am going to, and I appreciate y'all hanging out with me on this crazy stream. I'm going to see if my other, this is how I'm doing this. I am making a, I have to move it over where I can see you guys and this at the same time. This is the PDF I am in the process of making for my other channel. So we're deleting this stuff, but I'm using this as a template. So this is going to be my next PDF. So I'm working on it. It should be done tonight or tomorrow, and uploaded to my link tree. And if you watch the other video and you want a PDF of the exercises that you do, so you don't have to go watch the video every time, although I appreciate the view. I'm doing this. So there are things that are happening behind the scenes. I'm just, I'm slowly getting better at this streaming stuff, and running a business. Because this channel was just talk. I give you my opinion. That channel is a lot of work. This one, I look up documents and I read documents and I give you my opinion. We watch court cases. I do research, but not like that. That I am reading more. I am reading more research papers now than I did when I was working. So the name of my other channel is Evidence Through Motion. So let's see. Evidence Through Motion. I can let me unpin this comment. Have a good one. Evidence Through Motion. Oh, thanks, Roy. I forgot to do that at. This is my other channel, just for yeah. I used to watch Candace Owens like, I'd say 2 years ago, 3 years ago, but it seemed like when she had kids, like she just got a little weird, and that's just not my style.
All right, let's move to the next matter before us.
Ronnie, and that other channel, there is a video dropping, I believe, at 6 o'clock tonight.
And of course, I'm looking for my notes and they've disappeared. That's okay. It happens.
And I've heard people criticize the judge for reading. All judges read, especially when they're looking at
Let's
case
go ahead
law.
and address the state's motion to amend or clarify the
Oh,
publicity.
never mind.
order.
It dropped at 4
I'll
o'clock.
hear from all parties. And I know it has been briefed, but in responses, but I'll hear brief argument and then we can go from there. Mr. Ballard.
Thank you, Your Honor. With respect to this motion, I think as we've expressed in the past, everyone in this room shares the same goal, and that is to ensure that there's a fair trial that happens in this case. And we recognize that the court's pretrial publicity order is intended to further that goal. And again, as I've stated before, the state plans to try this case once. The state is also committed to complying with its ethical duties with respect to pretrial publicity. We have complied with those duties. We will continue to comply with those duties. The issue we bring before the court here is that there's one portion of the pretrial publicity order that can be interpreted to reach beyond those ethical requirements and have the effect of being what would be an unlawful order, an unlawful prior restraint on speech. And our goal, therefore, is to get an order that's clear, that's lawful, and that the state has the ability to comply with. And the issue with the order that the state has is the use of the term witnesses in the order. We believe that term's vague and ambiguous. Does it mean anyone with relevant information about this case? Does it just mean those people that are going to be subpoenaed to testify in this case? Or is it limited to just the prosecution team? And I think as we've expressed in our filings, we believe that the court intended that that term just be limited to the prosecution team because that is the way that Rule 3.8 reads. Rule 3.8 of the Rules of Professional Conduct that deals specifically with requirements for prosecutors talks about investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor. So in other words, the prosecution team. And there's no rule or case law or statute that expands the prosecution's duties beyond that group, the prosecution team. So with respect to clarity, we're seeking clarity as to what exactly does the court mean by witnesses. And we think the court just means the prosecution team because if that term stretches beyond just the prosecution team, then the order as written, we don't believe is a valid and lawful order because it would result in a prior restraint on certain speech. And at the very least would have a chilling effect on that speech. If the prosecution agrees that we have an ethical duty to take reasonable measures to make sure that those who are identified with the prosecution team are alerted to the requirements of the court's order and to make sure that they do not make a statement that the prosecutors themselves would not be able to make, a public statement. But if the order extends beyond that, then we have concerns because a prior restraint is an order that forbids certain communications in advance of the time that they are to occur. And as the Court of Appeals has recognized, the Utah Court of Appeals has recognized in State versus LM. And widespread publicity in a case does not itself justify a prior restraint. As the United States Supreme Court has recognized in Nebraska Press Association, there's no justification for a prior restraint unless it's clear that the further publicity, unchecked, would so distort the views of potential jurors that you couldn't find 12 jurors who could be fair and impartial. That's the high standard that applies in this case. And so in order to apply a prior restraint to persons beyond the prosecution team, the court would need to engage in a very detailed and demanding analysis. The court would have to make a factual finding of necessity, that the speech that would be restrained poses a risk of material prejudice to the ongoing judicial proceedings. The court would need to make findings that there are no less restrictive measures and that the prohibitions are likely to prevent the potential prejudice, and that whatever prohibitions this court decides on are very narrowly tailored. And as the state has explained, the Spencer versus State case from the Arkansas Supreme Court that just issued earlier this year is very helpful, I think, on this issue in explaining the analysis that applies to various different people that might be associated with the criminal case. You have attorneys, that category of trial participants, certainly the court has the highest degree of ability to be able to restrain the speech of attorneys. And in fact, as I've expressed, the ethical rules require that. But when it comes to trial participants, like witnesses, the standards are more demanding as far as restricting the speech of trial participants. And as the Spencer case pointed out, non-attorney trial participants, the court can impose a restraint on their speech only to the extent that the court first finds that any speech by those non-attorney trial participants poses a serious and imminent threat of material prejudice to the ongoing proceeding. And I think the court also needs to note that there are several people associated with this case who have very significant interests in exercising their First Amendment rights, in talking about how this case has affected them. And of course, can't say that one person's First Amendment right is more important than another person's, but there are certainly some people here who have a larger, some people involved who have a larger or a greater interest in speaking than others. And so I think the court needs to take that into consideration if this order is meant to apply beyond just the prosecution team. And then finally, as far as making the order, so we need a clear order, we need a lawful order, and then we need an order that the state can actually comply with. And the state recognizes that there are serious sanctions that this court can impose for violations of a court order, as we've just seen. And so we want to avoid these. We want to avoid litigation over whether there's been a violation of the order. And as it stands right now, we don't believe that there will be any issues if the court limits the term witnesses to just the prosecution team. We can comply with that order. It gets more difficult for the state if the term witnesses then applies even broader at this stage of the litigation, for the state to be able to comply with that order, depending on how the court clarifies what witnesses mean. Does the court have any questions for the state?
No, thank you,
Okay, thank
Mr.
you.
Ballard. Mr. Novak.
Thank you, Your Honor.
If you're going to be a witness, just shut the hell up.
I'm going to try to be brief because our views on the propriety of the court's order were set forth in a publicly filed document, which
Sanctions.
of course, the court has reviewed. And the first thing that I want to say is that the order that the court issued is not a prior restraint on any member of the public. And it's certainly not, I think as the state's motion suggested, some sort of a prior restraint on the press. This has nothing to do with the press. The order, as we noted in our papers, is directed at the conduct of and the court's expectations for counsel. So even if under that order that the court issued, somebody who we could all agree is a witness within the court's definition of that, made public statements which implicated Mr. Robinson's fair trial rights, the potential sanction is on the party who had a duty to make a reasonable effort to notify witnesses that they should not be doing so. If I represented a witness who was accused of saying too much publicly, the first thing that I would tell this court is the order isn't directed at the witness. The order is directed at the counsel for the parties. There may in the future be some theoretical situation where the court issues orders that control the statements or conduct of specific people, but this, or other than counsel, but this order is directed at counsel. And we have no, meaning Mr. Robinson's defense counsel have no problem complying with the order. And we also think that we understand what a witness is when the court uses that term. So it is our view that the court's order is not overbroad, it's not vague, doesn't put the state or the state's attorneys in some untenable position. And I think it's a little too simple to say witnesses are either everybody under the sun or people who are under subpoena at the last second, because counsel have not only the training, but a duty to figure out along the way who the potential witnesses are and to notify those people. And yes, down the road, maybe there's going to be an issue, and maybe an attorney on either side of litigation is going to have to explain to the court when a particular person did or did not become a potential witness in the eyes of that party. That doesn't make it impossible for the state to comply with the order. It just means that the state needs to be thinking along the way about who its witnesses may be. And that's why in our papers, we refer to it as a
He's just talking really slow.
potential lay witness, because we believe that the court intended it to go beyond members of the prosecution team, which are law enforcement officers, retained experts, retained consultants. And we don't believe that that creates an enforcement problem. We don't think it creates a compliance problem. We noted in our papers, and I'll emphasize here again, that the court's order actually places responsibilities on defense counsel that the rules don't. The rules have special guidelines for the prosecution, and the court has expanded that to include the defense, and we don't have a problem with that. I also think that
There's more.
the standard that the state is suggesting for when a potential lay witness, as we've defined that in our papers, may make public statements that violate the court's order. The best standard is actually the one that we believe the court should look to, which is the standard set by the 10th Circuit, because as the state points out, it may be that there isn't any Utah law on this issue. So it seems to me that the closest source of authority on this constitutional question is going to be the 10th Circuit, and that's the case United States versus Tijerina, and I'll spell it. It's Tijerina, 412 Fed Second 661, 10th Circuit 1969, where the court says that the constitutional balance between the First Amendment rights of a non-attorney participant and the defendant's right to a fair trial are properly balanced where extrajudicial statements present a reasonable likelihood of prejudicing a fair trial. That is a more protective standard than that which appears in Rule 3.6. And we think it's the appropriate standard which should be applied here. That's part of, as we've told the court before, a motion that we will bring, because we actually think that while the court's order is wholly appropriate, it's not vague, it's not overbroad, it's not a prior restraint, it doesn't create
You're telling the court what its motion is.
clarity for the state. We would like it to be a little bit broader in other areas, especially concerning the standard to be applied and the definition of what is the prosecution team, but that's not germane to here. So we think that while we understand the state's concern, we think that their motion should be denied. I think at the last hearing, the court actually clarified verbally from the bench what it meant by a witness. And I think that's pretty close to what we described in our papers as a potential lay witness.
I wish I had that superpower.
So I feel like if I say anything more,
Not for
I'm
the
gonna be
reasons,
reiterating
but, you know.
again what's already in our papers. If I've muddled it, I'm sure the court will tell me and I'll clarify it. I hope I haven't.
Thank you, Mr. Novak.
Okay, thank you.
All right, and we'll turn to the last matter. Anything further, counsel?
Yes, thank you, Your Honor. I do want to point out that the court's order as it's written does impose limitations on speech. And the issue here is whose speech? Is it just the prosecution team members, or does it extend beyond that? And limitations on speech are a prior restraint. The court's order says that, if you look at page 2 of the order, it specifically talks about lawyers, that lawyers cannot make a statement that would violate Rule 3.6 and need to inform witnesses that they cannot make similar statements, and then requires the parties to inform lawyers, excuse me, I'll just read it. Lawyers participating in the investigation or litigation of this case shall inform all witnesses, and then the list that I read, about the prohibitions contained in this order. So the order is prohibiting speech. And because if it extends beyond the prosecution team, it needs to have the findings that are required for that kind of prohibition on speech. That's what we're asking the court to do.
Thank you, Mr. Ballard.
Thank you.
All right. Let's turn to the final matter before this court, the motion for limited intervention and request for notice of motions to close, seal, or reclassify. And I'll hear from the parties on that.
Here we go again.
Thank you, Your Honor. David Ryman, representing the news media. Mr. Judd and I represent different groups of clients, so I'm going to invite him, if I miss anything, to weigh in after I'm done. But my intent, the issues are basically the same, so my intent is to address them for all of the conveners at once, and I'll be very brief. We have only ever sought, in this case, limited party status. That is what we do in every high-profile case that involves these type of closure issues. We are not seeking to be parties for all purposes. We are just seeking to be parties for the purpose of showing up and being heard, which we unquestionably have a right to do. We unquestionably have standing. That is settled law in Utah. And the last filing at least, that we got from Mr. Robinson's team that just came in, I don't know if it was a couple days ago, basically gets there at the end where it says, look, if you're going to grant them intervener status, it should just be limited. That's all we've ever sought. And so the question that was raised in the only case that they cite, this FL case from the Utah Supreme Court, that addressed whether we wanted to allow full party status under Rule 24 of the civil procedure rules in a criminal case, they said we don't need to do that. The woman in that case just needed limited party status. And so in a way, we're not really, the state really hasn't disagreed with this either, but we're not really disagreeing with Mr. Robinson's team. We have explained in our papers that we've cited the court to extensive authority saying that this is the procedure to use. It's the most efficient procedure to use. Otherwise, I don't know what exactly the suggestion is for Mr. Robinson's team that we're supposed to do from here on out, but it kind of sounds like just this sort of ad hoc show up anytime you happen to see something on the public docket that might affect the public's rights. And that's just not the orderly way that this typically happens. The other thing, as I've mentioned in our papers, that it does is it allows for the media to be able to take an appeal of a closure issue without having to rely on the court's extraordinary writ jurisdiction. And that was what they had to do in either Kearns Tribune or Bullock, where the media was not granted party status. And it is the situation that happened in FL, where they had to review her claim regarding records under extraordinary writ jurisdiction rather than invoking their appellate jurisdiction because she was improperly denied limited party status. So all of that authority supports the process that we are requesting in this case. We think it's the most orderly way to do it. And I'll end just by saying, there's been some discussion, and especially from Mr. Robinson's attorneys, about what rule it is that you need to do this under, whether Rule 24 applies. They seem to suggest that it doesn't. I will just point the court to two different rules that give you the authority to do what we're requesting aside from Rule 24. Rule 24 is in the civil procedure rules, but Rule 81, and particularly subsection F of that rule, says that the rules of civil procedure govern in criminal proceedings where they don't conflict with a rule of criminal procedure. That's the case with Rule 24. That's why courts in criminal cases have relied on that rule. The other one is Rule 31, and that's in the criminal procedure rules. And that gives this court the discretion, if it's not inconsistent with the rules, to fashion remedies and to deal with civil procedure, it's not civil procedure, but rather just procedural matters. And so that is essentially what happened in the FL case, which is that, whether you do it under Rule 24, whether you do it as a judicially created, remedy, it doesn't matter. It's the same, it gets to the same place, which is just that we are interveners for the very limited purposes that we've set forth in our order. We're not going to be here at every hearing arguing, we didn't take a position on the gag order motion that you just heard. We are only planning to appear and argue so that the court has the benefit of someone who's representing the interests against closure. Because as you know, and this is sort of why we're here today, a lot of time this just happens by stipulation, because these, the state and Mr. Robinson's lawyers, they may not want to fight over a particular issue. And so it really is a situation where no one really represents that interest. And the purpose of this whole process is to give the court the benefit of the briefing that we've submitted and the benefit of arguments to represent the public's right to attend these proceedings. So unless the court has any questions, that's all I have.
Thank you.
Thank you.
To the state, Mr. Beller.
Your Honor, as the state briefed in briefing on a prior motion, I think it's clear that parties have outside entities have the ability to intervene in a case as a limited purpose party when there's a statute, a rule, or case law that authorizes them to take specific action in a proceeding. And there's well-established case law that allows the media to intervene, to be able to appear and be heard on matters of public access to court proceedings and to court documents. And Rule 4-202.04 of the Rules of Judicial Administration also make it clear that the media can appear and do just exactly what they've done in the closed session that we held earlier. So it doesn't make them a capital P party to the case. It makes them a limited purpose party, and they certainly have the right to be able to do that. Thank you.
Thank you, Mr. Mellon. Ms. Visser.
Thank you, Your Honor.
God, why do freaking lawyers have
I
such
just want to clarify
cheeks
the
that
issue
wrinkle?
really, if we boil it down, is if these 23 media entities have met their burden to be a limited purpose party in this case. And I think another part of that is what that means. And really that is what we are primarily concerned with. What does that mean? What does that enable them to do? What jurisdiction is this court exercising over them as a result of them being a limited purpose party? Because I do believe that is another aspect of asking to intervene in a case. I do think that Rule 24 does not apply here. I think that's what we learned from the Supreme Court. They don't want individuals using Rule 24 of the Rules of Civil Procedure because it's too expansive. It's about broad entry into a case for many purposes. In the instances where our courts have allowed intervention into civil cases, and I want to be very clear here, the case law is in the civil arena. There are very few instances where we're dealing with this in a criminal case on appeal. So we're a little bit in the dark, and we're asking this court to kind of wade through and make a decision that potentially hasn't been made before. But I would ask the court to be very clear, no matter what it does, on what the media can and can't do in this case. And it sounds to me like the media has somewhat conceded that their role in this case is under Rule 4-202.04. And their role is to have a voice regarding closure, which has already happened today and will surely happen again. We have no objection to that. And to be clear, we're not objecting to the court's order about notice. We will provide notice. We will follow the court's order. We have no problem with it. But we do want this court to make the procedure very crystal clear. We want timeframes. We want orders saying this is when you need to respond, so that we don't end up with filings like we did this week, very shortly before the hearing, that we have to rush to respond to.
That I
We're
can
all
understand.
attorneys. We all know that these things happen from time to time. And we're not unreasonable folks. If they reach out to us, we will grant reasonable requests for extension, just so everyone is aware. But there was no communication.
I can totally
So
understand that.
I want
I'd be frustrated with that.
very, very clear what they can and can't do. It's less about semantics. This isn't about semantics. It's about substance. What are they allowed to do? If this court wants to call them a limited purpose party, that has to be, well, it's so you can exercise your rights under 4-202.04. And in doing so, this is what you need to do. That's what we're asking the court to do. And I also have some practical concerns that maybe need to be addressed with the court's clerk. For example, are we adding all 23 media entities to the court docket? Will they have access to all of the filings? I have had instances in the past where, unfortunately, parties have been added to a case and still receive documents that are intended to be private or non-public. I'm very concerned about that. So I think it would be appropriate, if they are going to be added to the docket, that it be reasonable, perhaps just the two entities that are requesting, the two conglomerate entities that are requesting, and that there be an order from the court saying if they receive something that they shouldn't have, they notify us in the court immediately and they delete it, they don't review it. At a minimum, I think that's necessary. But I also think it would be reasonable for this court to not to put them on the docket for that very same reason. So we don't think that they should have permanent status in this case. We don't dispute that they are going to be here. They're already here, as we well know. But we do think how that happens is important, and that this court should exercise its authority to make very clear what everyone's roles are here. And as I believe they put in their briefing, that they are neutral observers. Neutral observers. We don't want the chaos that is out in the media in this courtroom. So whatever this court can do to prevent that is what we're asking.
I think she's referring to
Does the
social
court have
media.
any questions for me?
No, thank you.
Thank you.
I think she's referring to the social media and the bull crap, because I don't blame her. Some of that
Thank
shit
you,
is.
Your Honor, just very briefly, I'm not sure what neutral observer is supposed to mean. We have interests in the case. We are here to advocate for openness and against closure. And so I don't think that's what counsel meant to imply, but that's the whole reason we're here, is that no one else represents our interests. That is straight down the middle of what the intervention rule requires. Just a couple clarifications. Counsel said we haven't cited any criminal cases where this has been allowed. That's not true. We cited the court to 8 different cases, all criminal cases in the state of Utah, where this is the procedure that judges routinely follow, including judges in this building. Counsel said that our role is strictly limited to advocating for what is under Rule 4-202.04. I don't think she meant this, but as the court probably knows, that just deals with court records. We're also entitled under governing constitutional case law to advocate against the closure of proceedings. And that rule does not technically apply to proceedings. It just applies to records. So just to be clear. But I think we have been clear, and this is all, I mean, there wasn't a whole lot of daylight between what council was just suggesting our role should be and what we've asked for, you know, which is just if they file a motion that seeks to prevent, that wants to classify something as non-public, like they did last night with the motion to disqualify. They were able to at least provide that to us. It's not very hard to send an email. That's all that we've asked for in terms of the notice. And then we have the right to be heard on those issues. And so I didn't really hear from council any reason why we should not be granted limited party status in this case, other than just some sort of, you know, confusion on their part as to what that would actually look like. I don't know how the clerk deals with parties on the docket. I assume you guys can sort that out. Typically, when we intervene on behalf of the news media in cases, they are listed because they are limited purpose parties. But the court can, you know, if it doesn't want to hear from us on a particular issue, it can certainly say that. I mean, we don't have any interest in weighing in on aspects of the case that don't have anything to do with the public's right to know. And so I didn't really hear an argument against what it is that we are asking to do. Just one last point on, well, two things. One is that council's chastising us for filing something late. I mean, this was a stipulated motion that got us here today. We weren't asked to weigh in on it. It was submitted to your honor with an order, you know, which they just assumed you would sign because it was stipulated. It was only because this court said, no, I'm not going to do that. I want to actually hear from the parties that we weighed in. So this was not your typical like deadline where we were invited to weigh in and just didn't. Last thing is, in terms of docket access, you know, Mr. Hunt and Mr. Judd and I are all officers of the court. If the court says you can have access to things that the parties are seeking to classify as non-public, but you can't share them with your clients until further notice from the court, that's fine. Some judges do handle it that way. Sometimes we just, you know, if they don't concern closure, sometimes we don't weigh in at all. But, you know, when they file things that they say we need to file this under seal and we're not allowed to see it, then the briefing for you is not super helpful, you know. And so typically the way this happens is we are allowed attorney's eyes only access to, you know, documents just like the state and the defendants would be. Their counsel can see things that are non-public, and we don't share them with our clients unless the court orders otherwise. And typically, if the court decides, no, this really doesn't need to be filed under seal, then we can provide it to our clients at that time. But this idea that our clients are somehow going to get access to things that are non-public, that's just not the way this typically works. If they're not public on the docket, if they're public on the docket, anyone can get them. And if they're not public on the docket, then our clients can't get them. And if there's a procedure where we can see them so that we can give the court the benefit of briefing substantively as to what it is, then we keep them attorney's eyes only until the court orders otherwise. So that's just typically the way this works. So thank you.
Anything further?
I don't know. Like, I kind of agree with the media on this
I'm not
one.
going to belabor what's already in the briefing. I do think it's concerning to just cite to a bunch of trial court cases without providing any pleadings or context for what occurred in those cases.
Oh, this bitch
I
again.
can't argue against what happened in other cases. This is our case. Our case is different. This court has already acknowledged it. There are many interests. We have
Your case is not
concerns
different.
about leaks, information getting out that shouldn't be out. I think those are valid. And our concern is access. I'm not impugning the integrity of these gentlemen. I'm sure they would act as officers of the court. But the more this court controls the information that ultimately it determines to be private, the more able we are to identify if there are leaks, if there's information that's getting out that shouldn't be, and who did it. So we are objecting to providing the media our pleadings in advance, even just to their counsel. We don't think that's appropriate. I don't see any authority for that. We're asking the court not to consider that. And we're concerned about opening the door to multiple other entities just filing in on this case, getting involved in the proceedings. We don't know exactly what media means either. So our position is and remains,
Oh,
they
shit.
can file what this court has authorized to file in the manner this court authorizes to file it and be heard in the manner this court indicates. We understand they're entitled to closure hearings, and I did make a mistake. We agree that they have standing to object to closure as well. So they should be able to file those things, but we do not agree that that requires status in our case. So does the court have any questions?
I sort of agree with what she's saying, but she acts like this is so different than any other case. It's really not. It's a state unaliving case. Just so happens to be a public figure and high profile. Other cases have been pretty high profile as well. There's cases on court TV, long crime trials that are streamed every day. She acts like this is the first time, like she's the first lawyer to ever do this. Oh my God. I'm like, where's my pearls when I need them? Sweet baby dumpster Jesus.
No, thank you.
Thank you.
All right.
Hey, Radis.
I appreciate the
This is
argument from
Tyler
all
Robinson's
parties throughout
hearing.
this day.
So,
Wish to commend the preparation and the
Oh.
quality of the arguments, as well as the civility that is sometimes overlooked, but I wish to recognize that and appreciate counsel's demeanor and their arguments today. I previously stated when we began that I would be issuing rulings on the first issue.
thanks, Spawn Trooper, for the raid.
When I began, I initially said October 14th. It's actually the October 24th audio recording of the closed hearing, as well as the October 24th transcript of that hearing. And so I wanted to just make that small correction. But given the in-depth and necessary arguments made in the closed hearing, I wish to take the time to issue a ruling that will say what will be disclosed and what will be kept private, because this court has a duty to do so. And I would rather do it right and take more time than to be rash and miss the mark. I need to be narrow in my approach, and it is an important issue. And so I plan to do that. In regards to the motion for limited intervention and request for notice of motions to close, seal, reclassify, I also wish to craft my order in such a way that is concise and addresses all the issues, the important issues brought up by all parties. And so I will be issuing that ruling at the same time. And so I will be issuing the ruling in regards to the state's motion to clarify court's pretrial and trial publicity order, and I am prepared to do so. Before I do that, what I want to do is, and counsel is being caught off guard because they were anticipating a ruling today, but what the court is intending to do is, and proposing to the parties, is issuing an oral ruling on WebEx that all parties can attend to. The reason why is I don't want to take a lot of time. These are important issues. I don't want to wait until January 16th. And I want to talk about potential dates. I don't imagine it will take longer than 20 minutes for this court to issue ruling. And I want to get the parties' input in regards to their thoughts of the court issuing an oral ruling on WebEx. And so I'll open it up to the parties.
Just
We
say
don't
yes.
have any
sit
objection
down,
to that,
shut
Your
up.
Honor.
Thank you.
We have no objection to that, Your Honor.
Yeah, same.
All right. Well, next comes the trickier part when you have a room full of attorneys trying to find a date that we're all available. Our staff.
There's a handful.
What dates do we have available for a 30-minute block before the end of the year?
Judge, we do have December 29th at 10 o'clock.
How does that appear? How does that date work for council?
That was 10 a.m. on the 29th?
Yes.
Your Honor, that works for
You're
Mr.
driving at
Robinson.
me.
Thank you.
Same for us.
All right. And to defense, in regards to Mr. Robinson, what is your position on, if it is on WebEx, he would be appearing by WebEx, or is there different thoughts?
So,
Your Honor, if we could just have audio only for Mr. Robinson to appear, since we will not be present, I would rather not have him in the courtroom without counsel present.
All right. Thank you. I appreciate that. So we will set the court's ruling on those two issues for December 29th at 10 a.m. And note that it will be audio only for Mr. Robinson per defense's request. And to the last issue is, well, before I issue my ruling, I anticipate, and counsel, are we still on the same page in regards to our January 16th hearing? Are we planning for that?
Your Honor, we are. We believe that most likely what we would anticipate doing is on January 16th, arguing our motion to disqualify the county attorney's office, which was just filed. That should give them enough time to respond to that. And also possibly we anticipate filing our own motion about the pretrial publicity order that has a little bit different take on it. That should be filed in plenty of time for us to argue that on the 16th as well. I think we have set aside the 30th, and that might be the one we want to save to argue our anticipated motion that's coming about keeping cameras out of the courtroom. And we will, I imagine the media will, depending on the court's ruling today, will want to weigh in on that one as well. And that would give them enough time as well. So that would be January 30th.
All right. And before I go to the other parties, the January 30th date, there was some complications. And so we have to find another date.
Okay.
And
So-
so I just wanted to let all parties know before we
With them-
lock in our schedule.
with them discussing the dates, I'm just going to mute it real quick. Think about this and how hard it is to schedule a date and a time on a case that they're all involved in. Now think about how many other cases that they have to do this same stuff with. And now you understand in other cases why shit is so backwards and takes so long, and why you can't get a hearing the next day if a hearing's canceled. Shit takes time.
Consideration dates and filings as well.
Yeah. The motion to disqualify the county attorney's office is going to be an
So as
interesting
staff
one.
is
We
doing
will be
that,
reading
they
that
are
whenever it's
looking for hearing dates. And one of the complications is, as a judge, I have 1,409 cases as of last Friday. And so trying to find a spot is tricky. And I'm grateful for my staff who work so hard to manage that calendar. So
149
that is
cases.
part of the reason for the delay. And we're trying to find a date because this is an important case, as is all of those cases. They matter to me.
The side eye.
Your Honor, while we're waiting, can I, if I might just make one point that might make things smoother as we go forward with the sealed filings? Just to Ms. Nestor's point, Mr. Novak earlier mentioned something about a redacted motion to disqualify. I don't know if that is something that they're planning to file, but I was just going to say sometimes, what we heard earlier about that particular incident is probably not something that we care that much about in terms of what they would redact. And so instead of opposing the motion to classify, if Your Honor, I don't know if this is the plan already in this case or whether that's what they were planning to do, but if they file a redacted version that, just takes out the stuff they care about rather than closing the whole thing, then we don't have to say anything and probably avoids.
I couldn't tell if it was 1,049 or 149. Either way, that's a lot.
I'm happy to confer with counsel if you'd rather us do that, if you don't want to do it by way of a court order, but.
No, I appreciate that input. I'll hear from both parties and then we'll get to the date.
Your Honor, I do anticipate going through and seeing what we can redact and working with the state on that as well and with media counsel. So.
All right.
And we agree that filing a redacted version is a good way to go. We can work together on that. As far as the January 16th hearing, the state will do everything it can to respond to these motions as timely as we can, as expeditiously as we can. I just want to note that January 16th hearing was set with the expectation, the previous expectation was that defense counsel was going to get us these motions before Thanksgiving. And we just got the motion to disqualify last night.
We had the
So
medication
we'll do
conversation
everything we
like 2 hours
can to
ago.
respond to those as expeditiously as we can and hopefully keep that date, but I'm not guaranteeing that we'll make that date.
All right, I appreciate the heads up. Going to staff, what dates do we have available for in lieu of the 30th? February 3rd, morning or afternoon setting?
Just got here. Stop crying. Stop yelling at me.
That works for Mr. Robinson, Your Honor.
Mr. Robinson planning on appearing?
Yes, Your Honor.
All right, thank you. All right, that concludes that particular issue about future dates, and I appreciate counsel working with me on that. We have December 29th at 10 a.m. for the court ruling on these two issues, and that will be via WebEx. And then February 3rd, January 16th, I believe that is at 1 o'clock. Is that correct? All right, that's in person as well with, I believe, defense has indicated Mr. Robinson will be present as well. And finally, February 3rd at 1 p.m. and also indicating that Mr. Robinson will be present. And in regards to the final issue, the ruling on the state's motion to clarify court's pretrial and trial publicity order. This is the order of the court. The court issued a protection order regarding pretrial and trial publicity in this case. The order prohibits attorneys who are associated with the prosecution and defense of this case from intentionally, knowingly, or recklessly permitting a witness, investigator, consultant, staff member, or other member of the prosecution or defense team to make extrajudicial statements, which, if made by the lawyer, would violate Rule 3.6. To that end, lawyers participating in an investigation or litigation of this case shall inform all witnesses, investigators, consultants, staff members, or other members of the prosecution or defense teams about the prohibitions contained in this order. The state moves to amend or clarify the court's use of the word witness as used in the publicity order because it is vague, ambiguous, or overbroad. The state asserts that there are over 3,000 lay witnesses of the alleged homicide. The state does not know if it must inform each potential witness or each potential and possible witness of the prohibitions in order, or whether the order applies only to witnesses who are members of the attorney's teams, such as investigators or experts. Due to the potential confusion, this court grants the state's motion and offers the following clarification. The word witness, as used in this order, applies to all witnesses who are part of the prosecution and defense teams. This includes any witness, including lay witnesses, whom the prosecution or defense has a good faith belief will be called to testify at a hearing or trial. The court also clarifies that the publicity order as written regulates the behavior of attorneys who are associated with the defense team or the Utah County Attorney's Office. It requires the attorneys to abide by Rule 3.6 and, in order to deter non-attorneys from making prejudicial statements, requires the attorneys to inform witnesses about the prohibitions in the publicity order. Informing witnesses about the prohibitions in the publicity order is a necessary step. It is,
I mean, I know Wisconsin and Utah obviously have different rules, but take note from Wisconsin in what a witness is, because they had their parade issue with
informing
Darrell Brooks.
witnesses about the prohibitions in the publicity order is
Take
a
a note from
necessary
what they did.
step toward not intentionally, knowingly, or recklessly permitting witnesses from making prejudicial statements. The publicity order does not regulate the behavior of any person who is not an attorney associated with this case. and this order will be signed today by myself and made public. Council, is there anything further that we need to address today?
Thanks, Your Honor. Yes, just the matter of having Mrs. Erica Kirk designated as the victim representative in this case. She has filed through her counsel a request to be designated as the victim representative. And we would like the court to formally acknowledge that request and formally designate her as the victim representative. And I guess along those lines, I wanted to make clear as well, I think this court stated earlier that there was an alleged victim in this case. And I know that there is case law talking about being careful about how we refer to victims and alleged victims. But in this case, that case law makes clear that those cautions don't apply with the same degree, where it's clear that we have a victim who was killed in this case. We don't have an alleged victim. We have an alleged perpetrator, but we do know that we have a victim in this case.
Thank you, Mr. Ballard.
I hate when they say alleged victim, like he's
Your Honor, on
not really
behalf
dead.
of Mr. Robinson, we certainly think it's appropriate for Mrs. Kirk to be designated as the victim representative if that is the desire of the state, just so there can be no doubt that she's afforded all of the rights assured to her under our state statutes, and we have no objection to that.
Thank you. Thank you to all parties. This court will recognize Ms. Erica Kirk as the designated victim representative in this case. Thank you. Council, I believe that concludes our matters for the day.
One
Or
more.
maybe
matter,
not.
Judge. If I can take the podium, Judge?
Yes, Mr. Gernander.
The purpose, I want to just give the court an update with respect to discovery. We've done that at previous
Thank you. I
hearings.
appreciate that.
The state has received approximately 13,900 files from law enforcement in this case. Approximately 300 of those we believe are duplicates. We have since provided to council, as of I believe this morning, 7,951 of those files. For the court's information, we had reached close to 100% had been disseminated as of last week, but we received quite a large batch within the last few days. So we were working on that. We still have a full-time paralegal that's dedicated to reviewing that, organizing it, Bates stamping it, and sending it out to council. Of course, there are necessary redactions that are being made along the way. Our next real hearing in this case, second matter, our next real hearing in this case is not scheduled till January 16th. We understand the court's caseload. We understand the difficulty of finding dates for a preliminary hearing. And we would like to make a request that the court calendar a preliminary hearing in this case.
All right. In regards to, and I appreciate the heads up and acknowledging the busy calendar of not only the court, but all of you. What, first of all, how many days does the state anticipate, which helps us in our calendaring efforts?
Judge, given that it's a probable cause standard and all the inferences go in favor of the state is asking for 3 days. We believe that we can present the evidence required to meet that standard, and that would also allow the defense to cross-examine witnesses and argue that standard.
Thank you, Mr. Gernander. Turning to defense, what are your thoughts?
Your Honor, we were not aware that he was going to make that request today. We do have one more member of our team that's not present that we would need to consult with. I don't know when he's talking about, but I don't see how we can set it until all the discovery has been received. And also we do need to deal with the disqualification motion just in case. So it doesn't seem like a good idea to set it before we have the disqualification hearing. We were only talking about a month from now. I think that should probably be resolved before we set any dates. But I am concerned about setting a date when we still don't have all the discovery materials. We have significant discovery materials that have not been received yet that we know are out there and coming and important. And we have to, have time to review it all and absorb it all. And I am going to be involved in another trial that is not over until the end of March. So that's going to take away my ability to work and process through discovery and communicate with our
Oh, that's a
patient.
you problem.
So it seems to me that with the understanding of what Mr. Grunander's trying to accomplish, that maybe we come to the hearing on the 16th with an idea about, we can have some conversations with with Mr. McBride and also with the paralegal that's dealing with all the discovery, and see realistically when we think we're actually going to have the vast majority of the discovery materials to us and how long it's going to take us to review it all. So maybe we could just come prepared in about a month to try to accomplish that.
Mr. Grunander.
Just 2 points, Judge. Sometimes I feel like we as practitioners sometimes lose sight of the purpose of a preliminary hearing. It is a probable cause determination. The primary purpose, according to case law, is to ferret out improvident prosecutions. So again, it's a probable cause standard. We are working as hard as we can, being very diligent with respect to collecting and disseminating discovery. Rule 16, subsection 2, speaks to the timing of mandatory disclosures. And it is it's a continuing duty. So as far as complete discovery being provided, in a case like this, complete discovery is going to be ongoing until probably trial. There are times when things become available during trial that are discovered to opposing counsel. But it says here, it says the prosecutor's disclosures must be made as soon as practicable following the filing of an information, except that a prosecutor must disclose all evidence that the prosecutor relied upon to file the information within 5 days after the day on which the prosecutor receives a request for discovery from the defendant. That's been accomplished. It then says, in every case, all material or information listed under paragraph A1 that is presently and reasonably available to the prosecutor must be disclosed before the preliminary hearing. So we are in the process of that, collecting it as quickly as possible, making any necessary redactions, and moving it to the defense as quickly as possible. But complete discovery is not required before a preliminary hearing. We have to
Just
provide
gotta
it
run
as
solo
quickly as
cup.
possible. We have that duty, and we continue to do that. So we think we can schedule a preliminary hearing and work towards that. I'm aware of Ms. Nestor's schedule. I know she's going to be in trial, I think, in February.
You can always cancel it.
And I'm probably overestimating the availability of the court's calendar, but the hope would be sometime in April to schedule a preliminary hearing.
All right.
I'll submit it, Judge.
Thank you.
Your Honor, can I just clarify one thing? I mean, the county attorney has made a decision, very public decision, to announce their intent to seek death the day that there was an arrest, which means that that obligation to provide us with the probable cause for everything they relied upon to charge applies now to their intent to seek death. And we're nowhere near getting that material. So that was their decision to release that. Normally that decision is not made until 30 days after a preliminary hearing. They made it in advance, and now they've got an obligation to tell me their aggravation and what they've relied on to make this a death penalty case. And we have not received that. So I'm waiting.
Made this a death oh, let me count the ways, lady. Let me count the ways. But Spawn, the motion to disqualify that she's talking about was they filed a motion today, apparently, to disqualify the county attorney's office.
But I'm just laying that out there for now.
Thank you. I appreciate the arguments from all sides.
Like,
I do
sit
not
down and
find
shut
there
up,
is any
woman.
prejudice in setting a date for a preliminary hearing. And it's not set in stone. And it
Oh,
certainly can
sweet
be moved.
Jesus.
I recognize that the parties.
She acts like this is like 1600 and you're like, or like putting this shit in like, in it, feather pen that can't be erased or can't be changed. It's like, no, we're putting a date on the calendar before the court's calendar fills up. Like, we're thinking ahead. Like, just Jesus, stop trying to argue everything. I know you're a lawyer, but there are just some points that just don't need to be argued. And welcome to me covering a trial and covering hearings and shit. I talk to the lawyers like they can fucking hear me. It is what it is.
Have a lot of obligations, but I also recognize the importance of this case moving forward. And if nothing more than this is a goal for the preliminary hearing, if it needs to be changed, the court understands that. That is what happens a lot in the criminal calendars and criminal dockets. What is a date that we may have available for a 3-day setting for a preliminary hearing?
There's just some things that don't need to be argued, like calendar dates. Like, we're just setting a hearing. We can always move. You know how many times hearings get delayed, removed from the calendar? Like,
All
shut
right,
up,
let's
shit.
take a look. So council, well, what dates in June?
June. Damn. My planner doesn't go out that far. Oh, no, it does.
All right. Council, I'll turn to you. Again, this is a goal. This is not a date that if we
She
can't meet.
pissed because she
there's
lost. Look
any
at that sour
prejudice that
ass
will be
face
attached
and
to
that
a
triple
party.
chin. I know
In
I'm not
regards to
talking with
May
my double
18th,
chin, but
how does that tentatively look for council?
May or June?
May 18th is the first date, I believe. So 18th, 19th, and 21st, just to give you the full range.
The state can make those days work, Your Honor.
come on. Come on. And we're behind a couple
Your Honor,
seconds.
we have availability the May 18th with the understanding and the appreciation that if it's not feasible for us to get done when we need to get done prior to that, we would ask to push it back. But we don't have conflicts at this time.
All right, thank you. So May 18th, May 19th, and May 21st. And this it will be in person. And do we anticipate, if that date moves forward, Mr. Robinson being in attendance?
Absolutely.
All right, thank you. I just want to put that on the record as well. All right, I don't want to be presumptive, but is there anything else? All right. Council, thank you again for your hard work today. And I wish you all, Mr. Robinson, a good afternoon. Court is in recess.
Thank God. All right, guys. Just 4 hours later, finally got it done. Holy crap, that was a long hearing. Thanks for hanging out with me for all 4 hours when I know that there are a few lawyers who are streaming this case. You chose to hang out with me and my snarky ass, and sorry, Spawn, I missed your stream. I was busy. I will go back and watch it. So we have dates for May. There are motions coming up. We also will be going over the Sean Ryan interview with the head of Charlie Kirk Security sometime in the next week. We have a lot to do. I did drop a video on my other channel. I do have us set to redirect over to alternate juror. We'll be doing a stream tomorrow at 2:00. Probably because I don't have documents in the Rebecca Park case, probably just doing an overview of it in addition to updates on some other cases that I found while we were just researching and shooting the proverbial shit. I appreciate everybody hanging out with me. Please hit that like button if you haven't. Please share the stream. Maybe someday one of those big lawyers will, want to have a conversation with me because that would be fun. Anyway, y'all have a great day. Say hi to AJ for me. I have to go spend time with my family. The little is out of the tub. If you hear her screaming, it's because he's trying to put pajamas on her and she's not having it. Y'all have a great night, and I will see you on the next one. Bye, guys.